Well, here we are again, talking about the Tati Westbrook without a crystal ball defamation lawsuit some more. There are now over 65 filed documents in this case. We're going to do a road so far in a minute, but today we are talking about the return of the Saltz. Saltzy strikes back. Saltzy's response to Brown and KJ's motion for sanctions, which motion for sanctions this early in litigation does not bode well for how this case is going to go. This is my first look. No, I have not read this. Yes, I've seen some of your responses on Twitter, but I cannot wait to read it with you. And since we've got over 100 pages, I feel like we need to get into it. Oh, the lights today are set to deep amber. Why? I reserve the right to change this to DEFCON red WTF-ery, but we're effery afoot. Why? Because this motion was brought by Brown. He brought the fuckery to the party. We'll see if Saltz brings some fuckery back, and then I reserve the right to change these lights to a little more red. We'll see. You guys let me know what you think in the chat or in the comments. For all of you on the replay crew, I appreciate you. It'll be timestamped below if you want to jump to certain parts of this. We're going to get into it. We need to go. There's a lot. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. All right, you guys, I've got my new facts greater than fuckery shirt on. What I'm looking for in this motion today, other than Saltzy's side of Saltzy's side, essentially, of the motion for sanctions. Look, if I had received a motion for sanctions this early in litigation, I would have looked at it and my first response would have been like, are you fucking joking me? Like, do you really want to go here? Because if we go here, we're going all the way here. So I want to see if this is brought. I want to see how much of a bring it comes back with this, because a lot of Saltzy's motions have the subtle shade and the lawyer sass. This could be guns blazing. So I'm excited to see that. I'm looking for a sassy footnote. I'm looking for properly lined paper, which we always get from Saltzy. I'm looking for their legal position on sanctions. Sanctions are hard to get. So asking for them is really kind of a dick move when the behavior is not beyond egregious. So we'll see what the response is, and I will be interested to hear what you think about the behavior that's alleged here. We need to do a quick road so far, but before I do that, I want to let you know, as I'm reading through the document, I am not going to take questions because I get derailed and then I forget my place. Like, let's just call it what it is. Your girl gets distracted AF and then I forget where I'm at. So I'm going to do all the questions after, and then we have Friday Night Live tomorrow to do questions. So before we jump into the road so far, I'm going to remind you now just to do the YouTubey things. If you are not subscribed, that would be awesome if you would do that. It helps with the YouTubey things. The thumbs up, the comments. Can't wait. Let's get into the road so far. We are here with the Tati Westbrook without a crystal ball defamation lawsuit. 65 docket items in. I'm getting ahead of myself already because I'm just like, what is happening? I have a case brief video that will catch you up on everything that has happened, but in some. Tati Westbrook, big old YouTuber up here on the YouTubes who none of us have seen. Gosh, it's going to be coming up on a year, isn't it? It was June the last time she posted a video. Sued YouTube channel without a crystal ball and its proprietor, Katie Joy, or KJ, as we call her up on this channel, because otherwise I'm saying way too many words way too often. So sued for defamation over tweets, an article, and shit that was said in videos. Tati Westbrook is suing on behalf of herself. James Westbrook's the other plaintiff, and then Halo Beauty is the other plaintiff. They are suing the two channels. Defamation is saying shit that's alleged to not be true and defamatory. Those are the things. There was then a motion to dismiss that talked all about Bye Sister and not so much about defamation. The motion to dismiss based on jurisdiction, like, hey, the state of Washington is not where this case should be, is what popped off literally all of the insanity in this case. Now, we're still at the point of the case where everything the plaintiff has alleged is deemed to be true for the court deciding these early motions, which is why I'm so confused why the fuck we're even in this sanctions motion, because we're not even fighting over facts yet. We're not even to the facts yet. We're just in jurisdiction, for the love of God. But the motion to dismiss based on jurisdiction is where everything popped off. In my opinion, it's because in the initial motion to dismiss based on, like, you can't hear our case here in Washington, KJ filed a declaration saying, I don't have any subs or viewers in Washington. I just don't. And then the hunt was on for subs and viewers in Washington, and they were found. And one of them is Lori Ann Barnhart. And we will hear a lot about her because she filed a declaration and Brown took issue because Lori Ann's declaration is pretty darn unhelpful to KJ's side. That declaration has prompted a wave of additional litigation, including the motion for sanctions and Brown's motion for, can I still be your lawyer? Please, mom, please let me still be on this case. We don't even have an answer to that yet. That's still coming. What's still coming in this case? Brown said he's going to file a Rule 11 motion for sanctions, which is in addition to this motion for sanctions, like another one. But remember, he filed a motion to shorten time, and the judge clapped back with, you can't even literally do that. Like, you literally can't file a motion to shorten time. They've been abolished for like 10 years or more. So you can't do that. You can't file that. So we're just striking that like it didn't happen. Like, we're going to go ahead and pretend you didn't just file a motion that legally cannot be filed in this court. So we're still in the waiting period for that sanctions motion that Brown alluded that he was going to file. And then there will be a response to that one, but we're still in the waiting time. Then Brown filed the, hey, so I'd really still like to be on this case, but maybe I can't still be on this case motion. Yeah. Saltz hasn't responded to that. That response should be due in a week or so, a little more than a week. So we're going to have another Saltz response to the, hey, I maybe can't still be on this case. Now, Brown could just fix that by stipulating to jurisdiction, because then Lori Ann wouldn't even be a witness, but that sure the fuck hasn't happened. So we're going to see. That's what's coming up. So today, oh yeah, and the court has to rule on jurisdiction because the lawsuit hasn't even really started yet. 65 docket items. Remember when we talked about the Keemstar lawsuit? Yeah, the whole thing was done in less than this, in less litigation than this. And we got a little glimpse because Keem won attorney's fees, and that was over $150,000 in attorney's fees with less filings than this. So that should give you an idea of how much money has been spent in this case already. And probably more, because there's a lot of videos to watch, because YouTube channels keep getting, referenced in these motions. I'm not the only one. Others have as well. But this case is also referencing back to YouTube channels and to KJ's own YouTube channel because stuff keeps happening. So with that, we're going to pull up this motion. We're going to go through the motion, and then there are 3 declarations. Let's have a look together. Look. It's already pulled up. Give your girl a hands up for figuring out how to do the YouTube-y things up here. I am going to get to questions at the end. Y'all chat amongst yourselves. I will be back to the chat soon, but we are here to talk about lawsuits, not people. So be kind. Let's talk about what these lawyers have done, if we appreciate a sassy footnote, and what we think of the writing. Because at this point, this is now Saltz versus Brown, it feels like. Like, KJ who, Tati what? We don't know them. We're fully in Saltz Brown land right now. We're fully in the lawyers fighting amongst themselves. All right, plaintiffs, I got 2 waters. I hope you have a snack. We're going to get into it. Plaintiff's opposition to defendant's motion for sanctions. I said in my motion for sanctions video, I said that Brown wrecking balled the door open and that Saltz et al. Were going to just march through it. And I'm interested to see how damaging this opposition is going to be, because I feel like there's going to be a lot in here. But let's take a look. Introduction. Defendant's motion to dismiss is pending. Yes, for the love of Christ, it is still pending. It's been 900 years. I have walked 9,000 miles since that thing has been filed. Like it's been pending for 100 years. It's never going away. Like never, ever. Like I will never, ever rule on jurisdiction. Maybe the court's amused by the lawyers fighting and is like, we are never, ever ruling on jurisdiction. We're going to let you all fight it out because it's amazing. No, I don't think the judge really did that. It was, speculation. I'm sure the research attorney is like, are you fucking joking? I want to be done. I digress. Defendant's motion to dismiss is pending, yet defendants are driving up litigation costs by accusing plaintiff's counsel of misconduct, failing to observe the local rules. Boom! That's what I've been saying. Boom. It's like, whoop, there it is. Driving up litigation costs, which literally doesn't make any sense to me at all. I don't understand why the litigation strategy is burn money in a dumpster and turn this whole thing into an actual dumpster fire, but the fuel for the dumpster fire is $100 bills. Failing to observe the local rules. Please tell me the footnote says 45. It doesn't say 45-line paper. See defendant's motion to shorten time, docket 61. That's kind of savage because defendant's motion to shorten time went strictly against the rules. There is other shade to be had in there, but that's a sassy footnote. And we'll look at all these footnotes. Sassy. We're getting to sassy. Also, the 45-line paper is a violation of, it's the standing order, not the local rules. Okay, it's fair. We got to move. Like, I need to be free. I had to move the arms down on my chair. That's how much flailing is going to happen. I'm already excited because the shade in the first sentence, and I'm not even done with it yet. And filing needless and duplicative motions. Yep. Irrelevant to the motion to dismiss. Also, yep. Because here's why. Because in the motion to dismiss, all of the facts by law are construed in the way that's best for the non-moving party, in this case, the plaintiff, Tati Westbrook. So all of the facts go to her just for the motion to dismiss. You fight about the actual facts later, but the facts go to her, like default point Tati. So all of this fighting makes zero of the sense to me, but okay. Since filing the motion to dismiss, defendants have filed 5 additional motions. It looks so bad in black and white. 3 of which require a written response from plaintiffs. Require, by the way. Require. It's not like plaintiffs can just ignore it. So this forces the other side to also drive up litigation costs because they can't just be like, this is stupid, fuck you, I'm not responding. It requires them to respond. Like, the court would be like, plaintiffs, why haven't you responded? You're obligated to respond. And one of which was struck by the court as improper under the local court rules. They brought it up twice in like one sentence. Twice in one sentence. They're like, bro, what? All 5 of these motions were filed within a 30-day period from January 18th, 2021 to February 18th, 2021, all after the court had a status conference with everybody saying, what we're not going to do is all of this back and forth nonsense. And then exactly what defense did was all of this back and forth nonsense. I can't wait to hear what the court has to say about it. Let's look at these footnotes. This is the 3rd of 5 motions defendants have filed since their motion to dismiss on December 2nd, which directly contradicts defendants' position that this court has no jurisdiction over the matter. I said that too. Your Honor, the defense, this is Brown for a minute, Your Honor. You don't have jurisdiction over this case. This case is proper somewhere else. Los Angeles, Minnesota, wherever. Not the fuck here. Not the fuck here. Also, Your Honor, he's doing this, he's doing that, he's also doing this. Please take control of this case and make a whole fuck ton of rulings, even though you don't have authority. Like, if the court doesn't have authority, the court doesn't have authority, they can't make rulings. But if they can't make rulings, they have authority. And then why are we wasting time with the motion to dismiss based on jurisdiction? Defendant's motion for status conference, docket 39. Defendant's motion for sanctions, docket 59. Defendant's motion to qualify counsel to continue representations. That's the, hey, Your Honor, I might have really fucked up. Can I please still be the attorney on this case? Yeah. See this court's minute order striking defendant's motion to shorten time. Yes, I'm sure the court and the research attorney are well aware, because I'm sure the research attorney looked at it and went, you've got to be fucking joking me. You can't file this motion. Footnote 5 is the last one in that paragraph. All 5 of these motions were filed within a 30-day period. See dockets 39, 51, 59, 61, 63. Hike. Moreover, rather than filing a single motion for sanctions, defendants filed the instant motion and served plaintiffs with a second duplicative motion for sanctions under Rule 11, which presumably will be filed after the 21-day safe harbor period expires. Oy. In the pending motion, defendants, again, the sanctions motion reiterated the 300-page precipice that we've already read on this channel. In the pending motion, defendants seek to distract the court with accusations of improper conduct and declarations filed, quote, for an improper purpose, because the proffered testimony shows, 1, that defendant Katie Joy Polson misrepresented the nature and scope of defendant's Washington contacts in her declarations filed in support of the motion to dismiss. Ouch. 2, establishes defendant have sufficient minimum contacts with Washington for this court to exercise personal jurisdiction over them. Moreover, defendant's motion for sanctions contains numerous misrepresentations, which is not the first time defendants have misrepresented and or misconstrued facts to the court. Oof. For example, at the February 2nd, 2021 status conference concerning the Nat Kennett declaration, Brown represented to the court that he was reading from Ms. Kennett's declaration verbatim. I remember this because I was on that call, yet the actual language of Ms. Kennett's declaration reveals that Mr. Brown recited words that were not in fact therein. Holy fucking shitballs. Okay, we have to get to the footnotes first, and then I'm going to tell you why I just said holy fucking shitballs. We missed footnotes 6, 7, and 8. Because this paragraph is like defendant lied in their declaration to the court. Misrepresented. Defendants have contacts with Washington, Lori-Ann being an agent, and the motions for sanctions has misrepresentations and misconstrued facts. So it's like they lied is essentially what that's saying. So declaration of Catherine Paulson, we know we've read that. Declaration of Kim Fulmer, we read that. And compare declaration of Jeffrey Blanco, which is Washington counsel for Tati Westbrook. All right, let's look at this. Mr. Brown's February 2nd, 2021 statement. This was on that court call, which has a transcript. I knew Ms. Paulson was not being honest with me when she denied that she was behind the hacks. So this is what Brown says that Nat said in her declaration. And he said that to the court. Nat Kennett declaration. I knew she was not being honest with me about her statements that she did not tell anyone to go after me, or that she does not, quote, tell anyone to do anything, period. Y'all, we're not even 2 paragraphs in. And what this says is that defense counsel said, I'm reading from this declaration verbatim, said that to the judge, and then read something that's not in the declaration. You literally can't fucking do that. Like, you cannot do that. And it's not even a, Your Honor, it says this. It's not a summary. It was, I'm reading this. There's a transcript and there's a declaration. How do you think you are going to actually say the wrong shit to the judge and not have the judge notice? Because there's a declaration and a transcript. And then you end up with a chart that says the transcript says this and the declaration says that. And those are 2 very fucking different things. And then this same attorney is going to turn around and ask the court to let them still be the attorney on the case because they might represent a necessary witness, after it's pointed out by plaintiff's counsel that they've lied to the court, which is absolutely something you can't do. Even if you don't like the things, you cannot misrepresent shit to the court. It is literally the most fundamental of rules, duty of candor. And no, I'm not talking about the Divergent movies. Candor, like, to the court. Like, every lawyer or law student, paralegal, anyone adjacent to the legal profession, if your head's not blown off by this right now, please let me know. Why am I missing something? Because what the fuck? I am shooketh. Shooketh. It's time. We have to go to red. 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 Why do we have to go to red? Because Brown has lied to that. Y'all. And I have no animus towards Mr. Brown, though I feel personally attacked by the 45-line paper because they hurt my eyes, but that's like a joke. I don't want to see any attorney do this. KJ has come for me her fair share of times. Every single person, whether you like them or you don't, deserves good legal representation, even if you don't like them. Every single person deserves good legal representation. What they shouldn't have is their lawyer lying to the court and running up the cost of litigation. How red can we go? That's pretty fucking red. We made it a page. We made it a page before we had to go red. And here's the thing. None of this would be before the court. None of this would be before the court if he hadn't brought the motion for sanctions. You lost it for yourself. Holy shit. Y'all. I looked back at the transcript and I looked back at this declaration when I saw that the transcript went up on one of the subreddits. And I remember this moment in the call. Okay, we're going to talk about this for a minute because this is actually a really big fucking deal. I remember in the call, the court was trying to wrap up the call, and then Brown was like, "No, Your Honor, it's bad. This is what Saltz allowed in this Kennett declaration, and this is why it's directly alleging that KJ is involved with the hacking." And he went in after the court was done. He brought this back up and opened a fresh. Well, he's going to open a fresh level of pain for himself with this because the court is not going to be stoked. I imagine his client is not going to be stoked. But that call was wrapping up, and then he went back in. And you can go back and watch the videos that the attorneys, a number of us watched this and covered it. And I talked about this a little bit, but I didn't know the gravity of it. I said, oh, we kind of got to the end, and then Brown kept going. And then the court was like, no, we're not. Brown said to the court, Mr. Brown represented to the court that he was reading from Ms. Kennett's declaration verbatim. Yet the actual language of Ms. Kennett's declaration reveals that Brown recited words that were not, in fact, therein. You cannot say, I'm quoting, and then say other shit. I knew Ms. Paulson was not being honest with me when she denied that she was behind the hacks, and Brown kept saying, Saltz is accusing KJ of hacking. The actual declaration said, I knew she was not being honest with me about her statements that she did not tell anyone to go after me, or that she does not, quote, tell anyone to do anything, period. Well, we've seen a lot of evidence that KJ tells people to do things. So we've seen videos with that contained therein. Y'all. All right. We're a page and a half in. We're going to be here. Get a snack. In addition, defendants' claim of bad faith conduct regarding Ms. Barnhart are based almost exclusively on hearsay evidence. 9, defendants cannot submit admissible testimony from Ms. Barnhart for the first time in support of their reply. True. And that goes to the fact that Brown is trying to squeak in evidence from Ms. Barnhart, but that would have had to come in his motion. The motion to dismiss that's defense shot across the bow. Here's the motion to dismiss. This is what we're arguing. This is the shit in it. Dismiss. And then the plaintiff gets to say, yeah, but this. And then the defense gets to say, no, they're wrong. What the defense doesn't get to say is, oh, but there's also this. You can't add more shit after if you are the defense bringing the motion. All of your shit has to go into the motion, and the motion has a page limit. And that's where the craft and art of being a lawyer comes in, because that's where you say what needs to be said and absolutely not a thing more. That's what that means. The unsigned Barnhart Declaration drafted by Mr. Brown, footnote 10. Defendants have repeatedly referred to the unsigned, unsworn, and undated declaration of Lorianne Barnhart as the, quote, first declaration, shade, and the declaration of Lorianne Barnhart filed on January 13th, 2021 as the, quote, second Barnhart declaration for the purposes of clarity and accuracy, shade. Plaintiffs refer to the signed January 13th, 2021 declaration drafted by defendants collectively as the unsigned Barnhart declaration. So Brown keeps trying to get the court to believe that the real Barnhart, like, will the real Lorianne please stand up, that the real Barnhart declaration is the first one, and keeps saying the first Barnhart declaration, like, this is the real one. This is the T. This is the first one. And they just came, no, that's the one that's not signed, meaning it's hearsay, meaning it's unsworn hearsay, meaning it has no evidentiary value, like literally zero. Shade in the footnotes. We're just Jesus. Defendants assert that the signed Barnhart, I love that they've changed it from first and second to signed and unsigned, by the way. It's brilliant. Defendants assert that the signed Barnhart declaration, which was signed by Ms. Barnhart under penalty of perjury, is false, while the unsigned Barnhart declaration, a series of 3 documents drafted by defendants' counsel and not signed under penalty of perjury, is factually correct. Ironically, this completely contradicts Ms. Brown's own email to Ms. Barnhart in early January, in which he indicates that the signing of a, quote, sworn declaration is, quote, generally a solid indication someone is telling the truth. I can't tell you how much I love using someone's own words against them. It's one of my greatest joys as a lawyer. Sometimes as a mother, definitely. If I was on Real Housewives, all I would do would argue with people with their own words. I wouldn't want to argue with anyone. I probably wouldn't be on Real Housewives. I'm really generally not that interesting. But in bringing up arguments in law, using what somebody else has already said and going, but you said this, it's just the best. And we saw that in the Taylor Swift suits as well, where Taylor Swift's attorneys used Evermore Park's attorneys' own filed arguments against them and said, but you argued this over here, and that argument still applies. It's look, I love. Ironically, this completely contradicts Brown's statement that generally a solid indication someone is telling the truth is that they sign a sworn declaration. And there it is. Let's go to footnote 12 on that. Oh, supplemental declaration. Yeah, we just cite the declaration. Further, defendants assert that Ms. Barnhart was eager to sign the unsigned Barnhart declaration is believed by the fact that Ms. Barnhart ultimately chose not to sign it and instead cut off her communications with Brown. I read that badly, or that's a rough sentence. Further, defendants' assertion that Ms. Barnhart was eager to sign the unsigned Barnhart declaration is belied. See, I read it badly. By the fact that Ms. Barnhart ultimately chose not to sign it and instead cut off communications with Ms. Brown. Well, yes. Agreed. And then that gets into the signed Barnhart declaration. Did we miss a footnote? No, we got into the footnotes. Perfect. Even more puzzling are defendants' attacks of Ms. Barnhart's credibility based on her personal health issues, which Mr. Brown himself was fully aware of as early as December 27th, 2020. Shade. Yet Mr. Brown had no concerns as recently as 2 days before the signed Barnhart declaration was filed about using Ms. Barnhart to testify favorably to defendants. We've all said that together on this channel. We've been like, but you were cool with her signing it for you, and you only had questions about it after she said, tell Cersei it was me, and laid KJ out in her declaration. Then you had concerns. Okay. Plaintiffs' counsel's conduct was not in bad faith. The filings were not frivolous, and therefore sanctions are not warranted. It's just so clear and concise. There's footnotes. These footnotes just cite to the supplement. C. Brown supplement, January 11th. Oh, this is the emails. January 11th at 8:02 a.m. We will be filing an objection today. I'd like to include a statement from you if you are on board with that. January 11th at 9:10. I'd like to stand up for you by filing the declaration if you'd let me. January 11th at 3:16. We're filing something today that addresses the threat Saltz made to you. It would be great if you would say that you took it as a threat and feel intimidated. Y'all know how I feel about that being in those emails because I had my moment when we did those videos. It would just be great if you would say you felt threatened. You cannot tell witnesses, clients, or anyone to lie. You could ask them, did you feel threatened? And if they say no, then no is the answer. Holy shit. And then they're going in again on these statements that make it seem that Brown was representing or offering to represent Lori-Ann Barnhart, which is the basis of what's coming up next, which is that, Your Honor, can I still be the lawyer here, please? Because Saltz still hasn't responded to that one yet. Yikes. All right. Clarification of facts, Your Honor. Let me tell you where they got it wrong from our perspective. Lori-Ann Barnhart on December 30th, during a meet and confer call to discuss the joint status report and discovery plan, plaintiff's counsel told Mr. Brown that Ms. Barnhart had deleted her Twitter account the night before and that Twitter would permanently delete the data from her account within 30 days of the account's deletion. Footnote 16. Levine declaration. So these are going to be in the declarations. Oh, so the declarations, we're going to get to see what was on that phone call. Brilliant. I love hearing what's in the phone calls. I love seeing what's in the letters back and forth. So many filings have happened in this case that we've been invited into like the back end communications that are going on because it's so messy. Notice in other cases, we don't have any idea what the lawyers are saying to each other, except that Taylor Swift case, because the letters are all included. But here we're going to get multiple declarations about the phone calls that were had, and we're getting the emails back and forth. And Brown included some of those emails in his motion too. Y'all are getting to see how the sausage is made in this one because we're getting all of it. Like it's a full frontal lawsuit at this point. The parties agreed to carve out an exception to the discovery stay to allow plaintiffs to subpoena Ms. Barnhart's social media account and information. And they filed that in their discovery plan. At no time during the call did Mr. Brown disclose that he had been in direct regular contact with Ms. Barnhart for approximately 1 week. Why is that relevant? Because Brown could have said, oh, I'm in contact with her. I will advise her to preserve evidence because evidence preservation is required. In fact, in an email to Ms. Barnhart later that evening, Mr. Brown indicated that he had deliberately withheld his communications with her. Quote, I spoke with Saltz today. Does it disappoint you all when they refer to him by Saltz? Because I feel like I want all the emails to just say Saltzy. So I'm going to just transpose it. That's not professional. That's not what they're calling each other. I think it's hilarious. They are planning to subpoena your Twitter account because they see that you closed your account and they think it might be evidence there about your connection with Katie. Yeah, because there's a video where you can see that they're DMing each other and she's in Washington and it might be relevant to the motion to dismiss. I did not disclose that you and I are in touch. In response, Ms. Barnhart wrote, figures, what are your thoughts? So that's more communication between them. This is going to be discussed. This email was at 6:18 p.m., which was not included with Brown's declaration. Oh, with his last declaration. So now they're intimating that Brown is not giving the court all of the information again. On January 10th, Ms. Barnhart sent a direct message to plaintiff's counsel Michael Saltz, though Saltzy did not see her message until January 12th, 2021. So these next few footnotes are all just citing where it says it in the declaration. So when we go through the declaration, we'll see it. Saltzy and co-counsel Elana Levine spoke to Ms. Barnhart in a series of phone calls on January 12th and January 13th that lasted approximately 16 hours in total. That's a lot of time on the phone. Oh, we're going to find out what happens. During the first call on January 12th, Ms. Barnhart forwarded certain email chains that were later determined to be only a portion of her correspondence with Mr. Brown. Plaintiffs' counsel reviewed the emails while on the phone with Ms. Barnhart and realized that the contents revealed a potential attorney-client relationship between Barnhart and Brown. That's the subject of that other motion. I'm not going to harp on it anymore. We're going to wait till Saltz responds on that one, and then you're going to get all of my feelings about the fact that I'd like to stand up for you in court may have established an attorney-client relationship at that time, even though when she cut off communication, she might have terminated that relationship. That's all I'm going to say about that. I promise I'm not going to stray. There's a lot here. There's a lot here to talk about. When asked about Mr. Brown, Ms. Barnhart confirmed that she believed that Mr. Brown was acting as her attorney because she repeatedly asked him for legal advice, which he provided. And he offered on multiple occasions to help her respond to the subpoena at no cost. However, Ms. Barnhart advised plaintiff's counsel that she had terminated her relationship with Mr. Brown. She also had told Mr. Brown that she was going to call plaintiff's counsel directly. Plaintiff's counsel then proceeded with the interview. All right. Footnote 25. Levine declaration, Brown supplemental declaration, quote, Ms. Barnhart, quote, is there anything I can do or should I try to ignore it? Page 43 of 221, Mr. Brown. These are the emails back and forth. Oh, they're just going to clip together that email conversation. We don't even have to go digging for it. Great. Mr. Brown, I'll have to think about this. For the time being, it's best for you not to make any contact with Katie and vice versa. I don't think we saw that email. Maybe we did. They're working hard to try to paint you two as a team, and that's not good for either of you. Well, it is irrelevant to Lori-Ann. It's highly relevant to KJ. So he is telling her to do things that are beneficial to his client, but if he's also her client, they might not be beneficial to him. I said I wasn't going to get into it anymore. Okay, it's hard. It's hard not to. They are working hard to try to paint the two of you as a team, which is not good for either of you. Miss Barnhart, don't worry. I will not say nor do anything without telling you first. Oh, like you're checking in with your lawyer. Mr. Brown, you have the right to object to the subpoena at a minimum. That would delay everything, which is, again, beneficial for KJ. And the judge might just say you don't have to respond. Mr. Brown, you have done nothing illegal. I also agree with that. I recommend that you sit tight, accept service if they come to your door, and then we can take it from there. We can take it from there. So I see where they're going with this. The next footnote is, Mr. Brown, do you have the ability to pay for your own lawyer if they do issue a subpoena? Mr. Brown, I can help with that. Mr. Brown, you don't need to spend any money or hire a lawyer to respond to the subpoena. Mr. Brown, I can give you some assistance. This reads like it's the response to the why Mr. Brown can't still be the lawyer on this case, because they're just putting all of the examples in there all right in one spot. Mr. Brown, I think I can help you with the response for no charge. It's very simple. Good luck. Good luck with your case. Unfortunately, and then this is Lori-Ann's. Unfortunately, I can see who the slime ball is now. I will call tomorrow. Miss Barnhart's explanation that she had terminated any potential attorney-client relationship with Mr. Brown is corroborated by the record. See the docket. Okay. So, that's putting all those emails together where Brown is talking to her. I want to know what you think in the comments and in the chat. Does it sound like he's representing her and her interests at that point to you? Because Ms. Barnhart had closed her Twitter account, Ms. Barnhart reinstated the account and provided Mr. Saltz with access. While on the phone with Ms. Barnhart, Mr. Saltz reviewed her account and asked her detailed questions about the numerous communications with Ms. Paulson's. Well, of course they did. After nearly 11 hours on the phone, can you imagine? It's like a full deposition. Ms. Barnhart advised plaintiff's counsel that she just took medication to address her personal health issues. Accordingly, plaintiff's counsel immediately adjourned the interview. On January 13th, plaintiff's counsel and Ms. Barnhart resumed their call. After approximately 5 hours completed the interview process. Time was of the essence because Ms. Barnhart was eager to correct the mistaken identity of the other Lori-Ann Barnhart. When I went through the declaration of Lori-Ann, all of the emails, that was the vibe that I got. It was, I want to, not be involved with this as much as humanly fucking possible. And what is the fastest exit? Like, where is the door? I want to be out of this suit immediately. Like, I don't want to be talked about. I don't want to be brought up on Twitter. I don't want to do any other things. How do I get out? And the other Lorianne shouldn't be kind of outed, if you will, shouldn't have, that's not the right person. That work address, that email address that are in those Fulmer declarations, those are not the right person. Can we correct it as quickly as possible? That was the sense I got from all of the emails between her and Brown was, but can you correct it? But can you correct it? But can you correct it? Miss Levine transmitted the declaration, that's interesting, to Miss Barnhart via email on January 13th. Mr. Saltz and Miss Levine then called her again to go over it with her. So they talked to her for like 16 hours. They sent her the declaration, and then got on the phone, and I imagine went line by line. Is this correct? Is this correct? Does this need to be changed? Mr. Saltz carefully recited the declaration aloud. I should just keep reading before I interject. Well, Ms. Barnhart reviewed the written version to ensure accuracy. After Ms. Barnhart made certain changes to her declaration, see, along with them, it's not like they're making the changes and sending it to her and be like, is this better? They're having a conversation, because over email, things get misinterpreted. Things over text aren't the same as a spoken conversation. After Ms. Barnhart made certain changes to her declaration, Barnhart subsequently signed the declaration without any difficulty, which was filed on January 13th. And the reason that's shade is because Lorianne was like, I can't get a printer. I don't have ink. I can't do this. And that's why Brown said, oh, she couldn't get it signed, and that's why we didn't file it. And then later Brown said, oh, no, I chose not to file it. Interesting. The reason it's interesting that Saltz is talking about Miss Levine and what she did is because the sanction motions about the Barnhart declaration is only directed at Saltz, but the other attorneys were also involved in this, which is not a bad thing. That's just the way that works. But Brown's trying to be like, Saltz did all this stuff, and it's like, actually, there's multiple counsel working on this. Meet and confer phone conference. Holy shit. Okay, Mr. Brown was either confused during the January 27th, 2021 meet and confer with plaintiff's counsel, or he purposely misconstrued what occurred. That's generous. Plaintiff's counsel never stated, among other things, that they, quote, rushed to complete their interview of Miss Barnhart and get her signature on the signed Barnhart declaration before her medication took effect. The record shows that plaintiff's counsel made every effort to protect Miss Barnhart and preserve her testimony, including pausing the interview after she took her medication and waiting until the following day when Miss Barnhart was clear-headed and alert to continue the interview. In addition, during the meet and confer, Mr. Brown never raised the following substantive issues on which the motion for sanction is based. A, wait, he never asked about it? A, the Kim Fulmer declaration, including whether any of Ms. Fulmer's testimony was submitted for an improper purpose. B, whether Mr. Saltz's direct messages to a friend of Lorianne were for, quote, oppressive reasons or improper purpose. C, whether any testimony in Mr. Saltz's January 4th, 2021 declaration was submitted for improper purpose. And D, whether plaintiff's counsel violated RPC 4.2 by communicating with Ms. Barnhart. Here's the thing. Look, the court's standing order, the rules say you have to meet and confer on the motions before they are filed. Brown said in his declaration, we met and conferred. We chatted. We couldn't work it out. The purpose of a meet and confer is like a kindergarten teacher taking two kids that are fighting over a ball and sitting them down and being like, can you explain to me what is happening? It's literally the purpose is to break up the kids and see what you can solve before anybody goes to the principal's office. The principal being the judge. That is the purpose of a meet and confer. Hey, we're filing this motion because of this. And what can happen is, oh, well, our explanation for that is this, and this, but we're happy to agree to this and this. And then we can file a stipulation if need be. That's what happened with the stipulation on the motion to not delete your shit and the stipulation regarding discovery. They met and conferred, had a conversation based on what was filed, had a conversation and went, yeah, we can agree to this. We don't have to bother mom. We solved it ourselves. Look, mom, here's the filing. We solved it ourselves. So Brown said in his motion that they met and conferred. And this says, what didn't happen was an actual meet and confer where we talked about the issues that were then going to be dropped in the motion for sanctions. Oh, the court's not going to like that. No. Let's cover the footnotes that we hadn't gotten to yet. Without any difficulty was the one where I was like, shade. Ms. Barnhart advised plaintiff's counsel that she used technical difficulties with downloading as an excuse to not sign the unsigned Barnhart declaration. There we go. See, Levine declaration. I don't know how to download everything on my phone, so it won't be done. So they're saying that Lorianne was just saying to Brown, I can't do it. It's so that he, I guess it's going to be in the declaration. I'm not going to speculate because otherwise we're going to be here for 17 hours and we don't need any of that. All right. This is all in the declarations. Oh, these declarations are going to have a whole bunch of information. Argument. Defendants failed to make a meaningful effort to confer with plaintiff's counsel prior to filing the motion. Can somebody just tell me, was it like 3 minutes ago that I said I should just read this instead of giving my opinion because then it's covered? Because when you know you're on the same lawyer train of thought is when you're like, oh, well, okay, that makes sense because of this and this and this. And then it's actually fucking written. I should just keep reading. This is what you get with a first look. You hear what happens in my head. And then I go, oh, there it is. This court's standing order for all civil cases requires that the parties make a meaningful effort to confer prior to filing a motion, and motions that do not comply may be summarily denied. I think that's what should happen here. The court was like, you did not meet and confer. Goodbye. Here, Mr. Brown failed to make a meaningful effort to confer. Wouldn't that be savage, though, if the judge was like, your motion for sanctions didn't have a meaningful meet and confer. Get the fuck out of here. Just nope. And just yeet it. Just, yep. Babs, yote the motion. I'm laughing because this is so ridiculous at this point. Just the no meet and like, how is there no meet and confer? How is there misrepresentations to the court and no meet and confer? And we're only what page is this? Where is the page number? Page 7 of 17. Fuck. Yote it, Babs. We're voting for it. Voting for the yoted. Here, Mr. Brown failed to make a meaningful effort to confer with plaintiff's counsel prior to filing the instant motion for sanctions. In fact, defendant's motion for sanctions could have been entirely avoided. Literally the point of a meet and confer, had defense counsel had a meaningful meet and confer with plaintiff's counsel. That's just rubbing it into the court. Like, he didn't do what he was supposed to. Neener. He didn't do what he was supposed to. In addition to explaining their interactions with Ms. Barnhart, plaintiff's counsel offered to provide Mr. Brown with correspondence and documents from Ms. Barnhart. Mr. Brown not only ignored the offer, but he also cut the meet and confer short. Plaintiff's counsel was deprived the opportunity to clarify many, if not all, of the issues identified in the motion. Okay, here's the thing. Is that willful? Is that Brown willfully being like, la, I'm filing a sanctions motion anyway? Like, we're not meeting conferring because I don't give a fuck because la. Like, it is how I see it, and nothing you can say to me is going to change it. It is how I see it. La. Because you can't actually do that. But it feels like that's what's happening here, which doesn't make any sense to me at all. Okay, I'm annoyed. Plaintiff's motion to strike prohibits portion. You can see the annoyance. It's early. Plaintiffs moves to strike portions of Mr. Brown's declaration and exhibits attached thereto pursuant to Local Rule 7G and, the federal rules of evidence. Plaintiffs object to and move to strike the following evidence. Supplemental declaration of Michael P. Brown, motion to dismiss, docket 43 and then they cite the different lines, which is hard because, 45-line paper, which contains copies of 3 unsigned declarations of Lorianne Barnhart, right, because they're not proper evidence. Sealed second supplemental declaration of Michael P. Brown in support of defendant's motion to dismiss. So there must be more information under seal regarding this Lorianne or the unsigned Lorianne declarations. That's my presumption based on it being included in here. Declaration of Michael P. Brown in support of defendant's motion for sanctions, including excerpts of Exhibit E that contain verbatim hearsay statements from the unsigned declaration. The unsigned declaration isn't proper evidence. So fair. In the absence of a procedural rule or statute, hearsay is inadmissible unless it is defined as non-hearsay under FRE 801D or falls within a hearsay exception under Rules 803, 804, or 807. We're not getting into the rules of hearsay today. But if we're curious about hearsay, look, it's like an entire semester. Hearsay is complicated, but once you get it, you're like, objection, hearsay. And then you feel like a boss in court. You're like, I understand. And then you're like, no, there's a hearsay exception. Anyway, that's a conversation for another day. The out-of-court statements in these paragraphs are submitted for the truth of the matter asserted and are relied upon by defendants in their motion for sanctions. True and true. I agree. Which I said when I covered that motion, I'm pretty sure. Truth of the matter asserted. In addition, 28 U.S.C. 1746 requires that a witness declare under penalty of perjury that the facts contained in the witness's declaration are true and that the witness sign and date the declaration. Yeah, we know you can't have an unsigned declaration. We're skipping that. Plaintiff's counsel's conduct does not warrant sanctions under 1927 or the inherent power of the court. I don't know why that is underlined. Probably it just didn't get modified. 28 U.S.C. 1927 sets a very high threshold before an attorney will be required to reimburse the opposing party for any portion of attorney's fees, given the likelihood that fee shifting could chill advocacy, meaning knowing that you're going to be on the hook for somebody else's shit might make you less effective. And the thing that your job is as a lawyer is to be an advocate for your client. As such, the court must begin its analysis with the presumption that an award of fees is not appropriate and that counsel's conduct falls within the acceptable realm of zealous advocacy, untainted by bad faith. So that's the standard as the plaintiffs see it. This standard is similar to the standard the Ninth Circuit applies to a request for fees. Because of their very potency, the court's inherent powers must be exercised with restraint and discretion. Yeah, it's hard to get sanctions. If conduct can be sanctioned adequately under existing rules, a court ordinarily should rely on the rules rather than on the inherent power to impose sanctions. In this case, there is no basis for an imposition of sanctions against plaintiff's counsel under the high thresholds and the court's inherent power. Plaintiff's counsel did not advance frivolous or reckless arguments or unreasonably and vexatiously multiply the proceedings by filing the declarations at issue. That is going to turn around in a mirror at some point as to who unreasonably multiplied the proceedings by filing declarations. Just saying. Nor were the declarations filed for an improper purpose. Meaning, if there's any purpose, if there's any legitimate purpose, like, defending a motion to dismiss based on jurisdiction, then it's not an improper purpose. There literally has to be no actual reason to do it other than, harass, annoy, and the other things that we saw. Plaintiff's counsel did not multiply the proceedings. Do you think that's why they included up above how many fucking motions defense has filed? Maybe. To be sanctionable under 1927, counsel's conduct must multiply the proceedings. I'm seeing a meme where it's like the list of Brown's motions, this line, and then it you. That's how I see it. In both an unreasonable and vexatious manner. I don't necessarily think Brown's motions are vexatious, but is it coming close? Let me know what you think. Even where filings are meritless and unnecessary, which is not the case here, sanctions are not appropriate if the other party is not required to respond. Here, defendants allege that the sanctionable conduct is the filing of 3 declarations in support of plaintiff's response to defendant's motion to dismiss. However, the 3 declarations, unlike motions, cannot multiply the proceedings as declarations are not moving papers containing legal argument. Rather, they simply set forth facts as would be admissible in evidence. As the declarations did not require a defendant to respond, sanctions are not appropriate. That is a very good argument because they didn't complain about motions. The only person who's filed motions that had to be look, they set it up above. The only person filing motions that have to be responded to are Brown, and they laid it out very clearly. How many did they say? This is why they said that. Defendants have filed 5 additional motions, 3 of which require a written response. So that gets into who's required to respond. In this case, it hasn't been plaintiffs, is plaintiff's argument. It's a good argument. Which also Brown would have known when he chose to file this motion based on research. So yeah, this is why there shouldn't be sanctions. Conclusion: for the foregoing reasons, plaintiffs request that the court deny the motion for sanctions. Let's see if we missed anything. The footnotes are all citing the law. This gets into Barnhart. I cut off all communications with defendants and defendants' attorneys. I therefore reached out to plaintiffs' counsel by telephone. We will see that in the declarations, I would imagine. Did I miss a page? Yes, I missed a couple pages. Damn it! I missed a few pages. That's more than a few pages. All right. Plaintiffs' counsel did not multiply the proceedings. That's where we were. Plaintiffs' counsel did not act in bad faith. Defendants failed to provide any evidence showing that plaintiffs' counsel acted in subjective bad faith. Subjective meaning, was there bad faith, which is present only if knowingly or recklessly raised a frivolous argument or argued a meritless claim for the purpose of harassing an opponent, or under the court's inherent power, which is present only if they acted in bad faith, vexatiously, wantonly, or for oppressive reasons by delaying or disrupting the litigation or by hampering enforcement of a court order. Are we delaying all of this right now? Because it feels like we sure are, but plaintiffs didn't file these motions. Here, none of the 3 declarations at issue were reckless or frivolous silence. I agree. I agreed at the time that the other motion was filed, though. Plaintiffs' counsel also thoroughly and carefully interviewed Ms. Barnhart, as well as reviewed the available documentation, including hundreds of interactions on Twitter. Oh, they went through her Twitter with her on the phone. Interesting. To ensure that her proposed testimony was truthful, in good faith, and supported by evidence. Defendants are simply attempting to besmirch plaintiffs' counsel. I love that word. And Ms. Barnhart to discredit her testimony, which is kind of what I speculated as to when the motion for sanctions was filed. I'm like, this is just another attempt to get this Barnhart declaration out of here, because the Barnhart declaration makes it very hard for them to win that motion to dismiss based on jurisdiction. Barnhart's testimony was properly obtained and vetted and was filed in response to Ms. Paulson's 2 declarations. I said that. For the proper purpose of providing evidence of defendant's Washington contacts. If KJ had not said what she said in her declarations, and if she had not gone on video with Lori Ann super chatting her, none of this would have come up. If she had said the amount of subscribers and stuff I have in Washington is minimal, then pulling up 1 doesn't prove that she was wrong in her declaration. Saying that she had 0 literally dangled the carrot for them to go, oh, really? None? Not 1? Not 1? I bet there is 1. Defendants speciously, the word choice in here is fantastic. Defendants speciously assert that, now defenses use speciously too, and I applaud it when they do as well. Assert that due to purported harassment by plaintiff's counsel, Ms. Barnhart finally relented on January 12th and reached out to Mr. Saltz. However, as evidenced by the record, by the evidence, Ms. Barnhart's primary goal in her involvement in this case was to clarify that she was not the other Lori Ann identified in the Fulmer Declaration. In her correspondence with Brown, Barnhart repeatedly requested that he tell plaintiff's counsel to correct the record so that the government employee with Barnhart's same name would not be at risk for potential harassment. I talk about that throughout the entire reading of Brown's 300-page precipice, where he included all of the emails back and forth, because she does say that substantially. Ms. Barnhart also told Mr. Brown numerous times that she voluntarily wanted to provide plaintiff's counsel with full access to her social media accounts. Despite Mr. Brown's assertion that he never represented Ms. Barnhart, Mr. Brown repeatedly talked Ms. Barnhart out of contacting Saltz directly. Had Mr. Brown simply followed Ms. Barnhart's request to clear up the mix-up with the other Lorianne as soon as possible, Ms. Barnhart likely would not have contacted plaintiff's counsel. Yet, instead of doing as Ms. Barnhart asked, Mr. Brown delayed discovery that Ms. Barnhart was willing to turn over without court involvement. Look who's delaying things now, Your Honor. Forcing Ms. Barnhart to approach plaintiff's counsel directly. Additionally, plaintiff's counsel spent more than 16 hours over the course of 2 days on the telephone with Ms. Barnhart, reviewed Ms. Barnhart's extensive Twitter communications with Paulson, and reviewed certain of Ms. Barnhart's correspondence with Mr. Brown. Plaintiff's counsel confirmed that the Twitter communications corroborated Barnhart's testimony relating to Ms. Paulson. Oh, so, okay, here's the thing. This is a full, I have been talking for an hour. Very quickly. This is them saying, look, we have receipts on Lorianne's declaration. Like, there are actual receipts. There are receipts to her declaration. And we found the receipts. You know why we found the receipts? Because we spent 16 hours going through her Twitter with her. Receipts. You know what wasn't attached to Brown's declaration? We need to re-gloss with my Gerard Cosmetics lip gloss. I love it so much. It smells good. Receipts. Unsurprisingly, the unsigned Barnhart declaration is based on substantive misrepresentations of fact. The shade. Y'all, the shade. Unsurprisingly, the unsigned Barnhart declaration is based on substantive misrepresentations of facts. We've got receipts. They've got bullshit. For example, the unsigned Barnhart declaration. Oh, they're going to go into it. Oh, see, these are the doors that get opened. And then the other counsel has no choice but to walk through the doors and be like, let me tell you why you're wrong. One, the plaintiff's counsel threatened her on Twitter to make her a party to the lawsuit, yet no such communication exists. Two, Ms. Barnhart told plaintiff's counsel that they identified the wrong Lorianne Barnhart when no such communication exists. Three, Ms. Paulson and Ms. Barnhart's communications were limited to, quote, a few brief online conversations unrelated to this matter, when Ms. Barnhart's Twitter account reveals hundreds of interactions. Yikes. Unlike Mr. Brown, it's not even shade. It's direct. It's just calling it the fuck out. It's just calling it the fuck out. Unlike Mr. Brown, plaintiff's counsel spent hours reviewing external documents, including Ms. Barnhart's Twitter account, to verify the accuracy of Ms. Barnhart's statement in the signed Barnhart declaration. This is like, you didn't do your job, but we did. Yikes. 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 All right, let's look at these footnotes real quick. Which footnote? Oh, this is the continuation from the footnote up here from footnote 62, which is Ms. Barnhart's same name would not be at risk for potential harassment. C. Brown declaration. These are the emails again. I hope the other Lorianne isn't being harassed. Look at what they've done to me and the other Lori. Will anything be put out so this woman's information will stop spreading? Do they know I'm not the other Lori yet? I think they still believe I'm the other Lori. And we went through this when we read all those emails going, look, she seems to me, reading Brown's 300-page precipice declaration, I was like, she seems actually genuinely concerned that this other person is going to kind of be on the shit end of what Lorianne has started on Twitter. And that was my take on it. Do they know I'm not the other Lori? So those are all separate instances in the emails of Lorianne saying, what about that? They can show up at Lori's house or work and harass her and her family now too. Can you tell me what's going on with the other Lori? I think she is going to get served other Lori. Maybe it would just be easier if I went and met with him myself. I have nothing to hide. For all I care, they can look at my internet activities. Yeah, but Brown cares, because if her internet activities are extensively connected to KJ, then it's bad for them. So Brown cared. Lorianne didn't care. Lorianne's best interest was to be like, look at my fucking Twitter. I don't give a shit. I'll reactivate it. Leave me alone. I guess I can just call Mr. Saltz to authorize YouTube and Twitter to give him all of it. I will call Saltz tomorrow. I understand that impulse. This is Brown speaking, I think. I understand that impulse, but you need to understand the type of person he is. Brown's like, please don't talk to him. Can you please talk with me before you do anything? Again, leaning towards him representing her because he's now telling her who to speak with. I understand this is very stressful. You should at least speak with me about it. All those emails. All right. Let's get into the rest of these. The Fulmer and Saltz declarations were filed only to address the misrepresentations made in Ms. Paulson's declarations as to the nature and scope of defendant's Washington contacts. Again, if KJ hadn't put in there she had 0 subscribers in Washington, literally none of this shit would have come up. If she had just gone into her analytics and been like, oh, I have a small percentage of viewers in Washington, then literally none of this would have been relevant. But no, she said not one. Defendants argue that certain references to Ms. Barnhart in the declaration of Kim Fulmer are irrelevant and harmful to Barnhart, yet it is defendants who repeatedly have publicized these references since Fulmer's declaration was filed, as well as repeatedly publicized Barnhart's personal health issues. Furthermore, Fulmer's inclusion of the reference to Ms. Barnhart's previous criminal charge was proper to show that 1, Ms. Barnhart is a Washington resident and has been for several years, and 2, Ms. Fulmer reasonably feared for her safety following Ms. Barnhart's threats based upon Barnhart's history. In addition, defendants' implication that the charge was dismissed on the merits is not accurate. Okay. The charge was dismissed after Ms. Barnhart completed a diversion program. As a DA who helped with diversion programs, not untypical. But also, if Brown is so worried that Kim Fulmer brought it up, and he keeps bringing it up and then misrepresents it, of course it's going to be brought back up again. I feel like Lorianne is ending up being the football in this entire thing, and I just don't understand why we're doing this, because sanctions aren't going to happen. You can't make sanctions happen. It's not going to happen. The Fulmer declaration also intentionally omitted the affidavit of probable cause in the charging document, which contained the details of the acts charged, including that they involved actual physical harm to a person. So because Brown brought this up again, it's just all in here because it has to be. Okay. Notably, Ms. Barnhart, under penalty of perjury, testified that, except for the statement regarding Ms. Barnhart being a government employee, Ms. Fulmer's declaration is entirely accurate. Moreover, all of the exhibits to Ms. Fulmer's declaration are public records, including the list of public employees readily accessible by a search of the internet. Okay. Defendants erroneously accused Saltz of stating in his January 4th declaration that Ms. Barnhart and Ms. Paulson engaged in a conspiracy to hide evidence. At least it wasn't a murderous conspiracy this time. Saltz made no such statement in his January 4th declaration. Oh, now Saltz is stating that they're misstating his declaration, which is something that comes up when I read the Brown things. I'm like, why are we reading into this? Like, it says what it says. Stop. Instead, Mr. Saltz testified that after reviewing hundreds of hours of defendants' vast social media content, he discovered that numerous social media interactions between Barnhart and Paulson had been deleted shortly after Fulmer's declaration. There were screenshots of those, as I recall, which identified a relationship between Barnhart and Paulson for purposes of personal jurisdiction. Mr. Saltz also discovered that after defendants' motion to dismiss for lack of personal jurisdiction, Ms. Paulson told her viewers on a YouTube live stream not to share where they live. There were screenshots of that too. Therefore, Mr. Saltz reasonably concluded that evidence relating to personal jurisdiction intentionally was deleted or obfuscated, and as a result, was more difficult to find. There is no mention of a conspiracy between Barnhart and Paulson. And he's like, no, they did delete shit. It just wasn't a conspiracy to do so. Shade. And then these all go into the Saltz declaration, which we're going to read, so we're not going to read it twice. Mr. Saltz's messages with Ms. G were not threats. Defendants seek sanctions against plaintiff's counsel based on allegations that Saltz sent threatening direct messages to Barnhart on January 1st. First, it is undisputed, though purposely vague in defendant's motion for sanctions, that Saltz did not send any direct messages to Barnhart. but rather sent direct non-threatening message to G. There were some statements, as I recall, in one of these, and again, Brown has filed so many long declarations that like Saltz directly contacted her, but there were screenshots that he was contacting somebody else. Second, Barnhart testified that she did not take these messages as a threat, and that's in her declaration. I remember that. Finally, Mr. Brown's only correspondence reveals that Barnhart did not take Saltz's messages to Ms. G as a threat. On January 11th, 2021, Brown wrote to Barnhart regarding Saltz's direct messages, suggesting it would be great if you would state that you took it as a threat and felt intimidated. Okay, it'd be great if you could just go ahead and say you felt intimidated. I hated that when I read it the first time. I hate it every time since. You literally can't do that. Had Miss Barnhart felt threatened, there would have been no need for Brown's suggestion. Fair point. And then these sites, let's see. These sites all just go to the declarations. Notably, the district court in the case cited by defendants did not use its inherent power to sanction the party's attorney. Oh, that's like legal research shade. It's like, hey, you cited this court for the proposition that there should be sanctions, but in that case, sanctions weren't imposed. That's just kind of funny. Barnhart terminated her attorney-client relationship with Brown, if any, prior to contacting plaintiff's counsel. Because remember, Brown asked for sanctions, saying, and after all of this, Saltz said she was represented by me, and then he spoke to a representative party, and he should be sanctioned because he spoke to somebody who was represented by an attorney. And all of us collectively went, what the fuck? You cannot say, I don't represent her, and then say, but he should be sanctioned because I represent her. So we all collectively went, WTF, and this is now going to get into that. Defendants simultaneously assert that Brown never represented Barnhart and that plaintiff's counsel must be sanctioned because... I've done it again. I've done it again. I've ranted before I continued to read. Damn it. But also true. Defendants simultaneously assert that Mr. Brown never represented Barnhart and that plaintiff's counsel must be sanctioned because they should have known that Mr. Brown represented Barnhart. Right. We're getting very close to estoppel, which is like, you can't argue two different sides of shit to the court. Like I would put this on a law exam and expect half of the class to say one way and half of the class to say the other way, because this is close. We're close to being barred from making this argument. In defendants' recently filed motion to qualify counsel, defendants argue for 6 pages that Barnhart could never have reasonably assumed that Brown represented her and acknowledge that Barnhart cut off all communications with Brown, i.e. terminated the relationship the day before she spoke with plaintiff's counsel. As such, defendants' argument in the instant motion is absurd. Ouch. How can plaintiff's counsel be sanctioned for violating Brown's attorney-client relationship with Barnhart if no such relationship actually existed, especially when defendants acknowledge their communications were cut off before any contact with plaintiffs existed, which meant either he didn't represent her, or if he did represent her, his representation ended before she called Saltz. Whether Brown represented Ms. Barnhart and whether any conflict exists due to that relationship are issues for the court to determine. What is clear in the evidence is that Ms. Barnhart terminated her relationship with Brown on January 11th, 2021, the day before she spoke with plaintiff's counsel. Therefore, plaintiff's counsel cannot have violated Rule of Professional Conduct 4.2. Let's look at these footnotes real quick. Those are just going to the declaration. This one is the Barnhart declaration. I cut off all communication with defendants and defendants' attorneys. I therefore reach out to plaintiff's counsel by telephone for the first time on January 12th, 2020. So that's just calling back to the Lorian declaration. Defendant's request for attorney's fees is not reasonable under the scope of 1927 and the court's inherent power. So this is legal argument as to why there shouldn't be attorney's fees granted. We already read that. Conclusion. Oh, we're done with the motion part at 1 hour and 13 minutes. Guess what's next? Guess what's next? Saltz's. No, I think whose declaration is next? There's a declaration next. Declaration number 1. Whose is it? The declaration of Elana Levine. All right. Everybody take a drink. Let's get into these declarations. How many pages is this one? Oh, 58. Fuck. Okay. Okay. We've got this. Get it. If you need a bathroom break, I understand. I'll just be here reading this when you get back. I, Elana Levine, am an attorney. I represent the plaintiffs from the beginning. Ooh. Let's just. From the beginning, my interactions with Mr. Brown have been unnecessarily confrontational. Out the gate. Because of Mr. Brown's false accusations and misstatements since the outset of this case, it is now official policy in our office. Holy shit, there's an office policy. Why is that so funny to me? Probably because we're over an hour. And it is now official policy in our office that there should be at least 2 attorneys on all calls with potential witnesses and conference calls with defense counsel in this case. This unfortunately has caused plaintiffs additional expense. Look, this should never have to happen. This is not how attorneys generally interact. You can advocate for your client while still working with opposing counsel and not misrepresenting shit. Like the fact that it's like, oh, everything we say is going to be misrepresented does drive up the cost of litigation. And it just doesn't need to happen, because one of the things, you can disagree with things and still not misrepresent things. Like that's not part of the job of being a lawyer. In fact, it's the opposite. As stated in my declaration filed January 27th, in advance of the status conference, Mr. Brown submitted a declaration containing several incorrect and or misleading statements when, upon close examination, do not match up with the record in this case. Those do not match up either way. These discrepancies have also led to an increase in time and expense for plaintiffs to address. Fair. No document could have been filed by plaintiffs' counsel for an improper purpose. Multiple attorneys have been involved with the drafting and filing of the pleadings, which also goes to the fact that this sanction motions is only against Saltzy, but the other attorneys also have been working on this case. Plaintiffs' counsel's interaction with Barnhart did not overlap in time with Brown's communications with Barnhart. On January 12, 2021, Barnhart made contact with Saltz, a partner in my firm. Barnhart's a resident of Washington. We already know these things. Plaintiffs did not submit Barnhart's testimony for an improper purpose, but rather to establish the jurisdiction is appropriate and to refute Defendant Paulson's testimony that she has no subscribers in Washington, nor derives any income from the state of Washington. Oh, right, because remember, Lorianne was a paid member of her channel too. And to refute Ms. Paulson's subsequent testimony that she had only been, quote, in contact over social media with Lorianne Barnhart on a few occasions. Right, the hole kept getting dug deeper. Saltz connected me onto the call on January 12th, 2021, so that we could interview Barnhart together. We spoke to Barnhart on a series of phone calls January 12th that in total lasted approximately 11 hours. The interview process was so lengthy because we did not rush Ms. Barnhart during our interview, but rather gave her time and respect to tell her story. Is that shade at Brown for not being respectful? Let me know what you think in the comments. Let me know. Is that shade at Brown for not being respectful? The length of the interview process gave us time to investigate and corroborate Ms. Barnhart's statements in real time. During the January 12th telephone call, we get to hear what's on the phone calls. During the January 12th telephone calls, Barnhart forwarded numerous emails to both Saltz and myself containing communications between Barnhart and Brown. I understand based on our telephone conversations that Barnhart's emails had potentially been hacked and or deleted prior to our call. Oof. Mr. Saltz and I reviewed and discussed the emails that Barnhart sent to us, some of which are discussed in Barnhart's declaration. Upon review of said emails, we immediately stopped our interview with Ms. Barnhart and explained that we were concerned that the contents of the email established an attorney-client relationship. Okay, let's look at these footnotes real quick. As stated in Ms. Barnhart's declaration, she was not only a paying member of Defendant's YouTube channel. I keep saying things and I should just keep reading because the information's here. For several months, but that the two women had communicated hundreds of times for the better part of 2020. I understand now that we did not receive all of the emails between Barnhart and Brown. I have reviewed the emails contained in docket 43-1, that's Brown's declaration, Exhibit B, And there are emails between Barnhart and Brown contained therein that I had not previously seen before defendant's filing of said document. Additionally, Mr. Brown omitted some communications from his filings. True and correct copies of the missing emails are attached. There's more emails. Goody. This is, they go, wait a second. These emails look like you are represented by him. Holy fuck. Stop. Time out. Are you represented by Brown? Because if so, we shouldn't be talking to you. Hold up. Wait a minute. Mr. Brown, or at least a prospective attorney-client relationship, had formed. It was at this point Barnhart told Saltz and myself that she thought that Mr. Brown was acting as her attorney because she kept asking him for legal advice. He kept giving it to her. He kept saying that he wanted to represent her in responding to the subpoena, and he wanted to help her make a record of complaints against Mr. Saltz. Ms. Barnhart mentioned to Mr. Brown that she wanted to possibly consult with legal aid. Mr. Brown dissuaded her, telling her that he would represent her at no cost. Both Saltz and I asked whether Barnhart considered Brown to still be her attorney. Barnhart indicated that she terminated the relationship with Brown, called him a slimeball. It's just all in here. Told Brown that she was going to call Saltz and cut off communications with Brown. Ms. Barnhart also told us that she informed Brown that she would not be signing any of his drafts. I will not be signing that. And made up an excuse that she didn't know how to download them on her phone, hoping that he would take the hint and leave her alone. Let's look at these footnotes. Docket 43-1. This is that long Brown declaration, page 30 of 221. Yeah. Is there anything I can do, or should I try to ignore it? These were all up above, so we're not going to reread them because these were all in the motion. These are in the motion too. Do you have the ability to pay for your own lawyer if they do issue a subpoena? I want the court to know what he's doing to harass you. Snohomish County Legal Aid Services, maybe they can help me. These were all in the above. Unfortunately, I see who the slime ball is now. Those are all in the emails too. Okay. Hoping that he would take the hint. Footnote 17. This situation is... Holy shit. This situation is akin to someone turning down a suitor with a polite excuse. Sorry, I'm washing my hair that night. Okay, Elana Levine. I see you. Lorianne said she felt like he was a slime ball and that he wouldn't take the hint. She's like, I can't do it. I'm washing my hair. Oh my God. Wow. That is our top sassy footnote right there. That might get a sassy footnote award. If something tops it, y'all will have to let me know, but that is our top sassy footnote. Monuments to the gods of speculation is probably my favorite line that we've come across so far, but murderous conspiracy is second. And sorry, I'm washing my hair is now my favorite sassy footnote. Like, we need a better word. We need a better word for sass. Okay, I need to recover. We're going to be here forever. Holy shit. We're going to be here forever anyway. Just buckle up. Let's keep going. He wouldn't take the hint to leave her alone. Now he feels like the creepy guy at the bar, right? We then double-checked the emails Miss Barnhart sent us and confirmed that what she had told us, and that her communications with Brown appeared to have been cut off. So I, like, in my head, what I imagine happened is they're like, wait, it feels like you're represented. We're going to stop talking. We're going to review these emails. Thank you for your explanation. We'll call you back, which is probably why this took so long. Based on our review and conversation with Miss Barnhart, Mr. Saltz and I were satisfied that the emails that Ms. Barnhart provided us corroborated what she said regarding the termination of that relationship. As such, we proceeded with our interview. At a certain point in our questioning, Barnhart, she informed us she takes medication for personal health issues. She later informed us that she has taken medication and that the side effects will make her foggy. Based on this information, we told her we would like to end the interview. And again, Brown represented they were rushing to get her to sign, and they're representing, no, we'll talk to you tomorrow. You have a good night. That's how this reads to me. Where's footnote 19? Because we didn't get to that one yet. Footnote 19. Ms. Barnhart cut off any and all communications with Brown on January 11th concerning any potential representation in this matter before our initial communication on January 12th. The timeline is confirmed in defendant's motion to qualify counsel, which states at page 4. So they're using his own motion again, which states at page 4, even if the emails could reasonably be construed. That was my favorite argument in that motion. To offer representation, Ms. Barnhart's own testimony establishes that she rejected that putative offer. Indeed, she testified that she was suspicious and not comfortable with Mr. Brown as her attorney. Oh, back to I'm washing my hair. And she therefore cut off all communications and proceeded to speak with plaintiff's counsel the following day. So Brown knew and argued that she cut off communications, and then went to the court and said that you should sanction him because she was represented. It's literally the worst argument in that motion. They could have filed a motion for sanctions without adding the motion for represented counsel, and I think it's going to bite Brown in the ass. I don't think the court's going to like it. It is not good. It's not good because he's arguing out of both sides of his mouth, and that's literally what the fuck you can't do. All right, let's see what else Elana Levine has to say. I took notes during the phone calls on January 12th and drafted Ms. Barnhart's declaration. Oh, so Saltzy didn't write it. She did, which again is how law firms work. And there's nothing wrong with that, except he's sanctioning Saltz saying you wrote this. And then they're like, bruh, nah. I took notes during the phone call, drafted the declaration based on our telephonic conversations and the voluminous documents provided by Barnhart. After I drafted the declaration, I sent it to Saltz, who edited the document, added the screenshots of the evidence provided by Barnhart during the phone calls to prove the veracity of the statements. Look, the receipts got added. Why am I not surprised that Saltzy's the one adding the receipts? Like, I'm not shocked by that. On January 13th, Saltz and I continued to complete the interview process with Barnhart. I subsequently transmitted a draft declaration to her via email. Saltz and I then called Barnhart to go over it. Because Barnhart had disclosed to us that she had personal health issues that caused her to have trouble focusing, Saltz took his time on the call to verbally recite the entire declaration. So he read it to her. Is this correct? Is that correct? Is this correct? Is that correct? Is this correct? I love this so much. Tell Brown it was me. The ladies coming through in this case are giving me life. I followed along with the reading and informed Barnhart that if Saltz was reading too quickly at any time, she should feel free to interrupt him and tell him to slow down. We proceeded to go over the declaration word for word, line by line, sentence by sentence to ensure it was accurate. The shade of like, what did you do, Brown? You sent some emails back and forth and said it should be great if you could go ahead and say you felt threatened. I did not allow any paragraphs to go by in the declaration without stopping and checking with Barnhart to ask if the wording was accurate and if she had any edits. Ms. Barnhart did have some changes to the document, which we made. We then resent it to her. We then resent her the corrected declaration. She executed the declaration. She signed it and sent it back. I filed the document with the court later that day. Saltz and I, remember when that happened? I feel like we were all so much more innocent then. And we were like, damn, that happened. Saltz and I spent approximately 5 to 6 hours on the phone with Barnhart on January 13th. There were some technical issues with Barnhart's Wi-Fi that day, so there were multiple telephone conversations that day. 16 hours total versus like whatever the emails were. From the time of our initial phone call with Barnhart, she emphasized that time was of the essence. Time was of the essence. Specifically, Barnhart had stated that the entire purpose as to why she reached out to Brown in the first instance was because she wanted to ensure that the court record was corrected as to her identity and the other woman bearing the same name, which Brown failed to do. And this is what it felt like that whole time, which we've already talked about. It felt that way to me too, that she really was worried about the other person. And Brown didn't correct it. I think at some point, Lorianne was like, oh, you're using me as a piece in the chess game. I just wanted you to correct the record. Like at this point, I'm done with KJ. I'm done with you. And I'm done with all of this. I just wanted you to correct the record and you didn't. Like, why are you holding this bomb to like launch at Saltzy later? Just correct the motherfucking record. Maybe that's where the I see you the slime ball now comment came from. At no time did I or Mr. Saltz pressure Barnhart to execute her declaration or rush her to sign it. On the contrary, we informed her that she is under no obligation to execute a declaration with our office if she did not want to execute it. We informed her that we are not her attorneys, that we only represent plaintiffs, and with any other witness, as with any other witnesses, I told Barnhart that my only request of her was that she be honest and that she is signing a document under penalty of perjury. We informed her that we cannot advise her on any legal issues and that she is free to obtain independent counsel at any time, including before signing her declaration. Barnhart indicated that she understood we're not her attorneys, that she wanted to proceed, and it was her paramount desire to clear up the mix-up with the other woman bearing the same name as soon as possible. Once again, Brown has caused plaintiffs to bear unnecessary additional expense in this matter. Had he simply followed Miss Brown's stated desire to contact plaintiff's counsel and clear up the mix-up with the two identical names as soon as possible, Miss Barnhart would more than likely not have terminated her relationship with defendant's counsel. You lost it for yourself. That is just like, hey, Brown, if you had just called us, we could have clarified the record, and then there would have been no tell Saltzy it was me moment, because she wouldn't have been pissed, because she would have just been like, thank you for doing the thing that I asked. The thing that I asked was that you cleared up so that the other Lorianne doesn't get any hate. That's all I wanted. That's all I wanted. Holy shit. Holy shit. That is just the pin in it, isn't it? Of Elana Levine pointing out as clearly as possible, had you just done what she asked you to do, we wouldn't all be here dissecting this again, showing that you have misstated things to the court as they point out in this motion. Yet instead of doing so, Mr. Brown used his communications with Barnhart as an opportunity to usurp the subpoena process, thus delaying discovery that Ms. Barnhart was willing to voluntarily turn over without court involvement, and to pocket the error made in the Fulmer Declaration to use later as a weapon against plaintiffs. Boom. As a surprise at a later date. Look, this is not how this should be done. And the court is not going to like this at all. The court is going to be like, you're telling me, wait a second, you're telling me that all of this could have been resolved if you had picked up the phone and called them and just said, y'all got the wrong Lorianne. Can you correct the court record? The real Lorianne is very concerned about it. She's talking to our office and doesn't want the wrong Lorianne to be threatened. Can we just file a stipulation showing that that's the wrong Lorianne? But you couldn't just do it because you wanted to fuck with us. Well, guess what? It blew up in your face. Also, fucking with opposing counsel's literally not a strategy or a proper purpose of litigation. But this case doesn't prove that to any of y'all. That's why this case is so crazy. It's not a valid purpose. Like, fucking with other counsel is not a valid purpose. Oh, yikes. All right, these are all just the declarations. The record filed by Mr. Brown confirms Ms. Barnhart made numerous requests of Brown to ensure plaintiff's counsel knew they needed to correct the record so that the woman bearing the same name would not be a potential risk of harassment. 24. And I think that's generally because Lorianne knew how she had behaved on Twitter. And look, the entire communities surrounding this case get wild. The death threats have gotten wild. The doxing is wild. It gets wild. So because Lorianne was a knowing participant in that, and I'm not saying she wasn't, she was a knowing participant in the pro-KJ, anti-KJ wild shit show circus that is Twitter, I can see why she was like, this other woman has my name, but I don't want her getting the emails that people think they're sending to me based on this whole thing. Yikes. However, after asking Mr. Brown for nearly 3 weeks to make sure that the record was corrected with regard to the other woman bearing her same name, Barnhart became upset that Brown had not made any contact with plaintiff's counsel to inform them of the issue. That just looks bad. And he still did not know if plaintiff's counsel were aware of the issue. Footnote 26. See docket 43-1, page 166. Because they can't cite the line number because it's on 45 line paper, so the lines don't match up. Normally, you would just be able to put the line. I don't know if they knew. This is them saying that this is Brown saying, I don't know if they knew it would make it even more remarkable that they haven't corrected the record. So this is Brown telling Lorianne they don't know. Plaintiffs don't. Plaintiffs don't know that they have the wrong Lorianne, so they can't correct it. No wonder she was like, oh, I see who's the slime ball now. Meh. I get it. I get the frustration. This is why people hate lawyers. This kind of shit is why people hate lawyers. However, asking around for 3 weeks. Okay, we got that. Further, after stating several times to Mr. Brown that she wanted to call Mr. Saltz and voluntarily provide him with access to all her social media and email accounts because she had nothing to hide and wanted to be done with this case, Barnhart had become upset that Mr. Brown would talk her out of doing so. To date, plaintiff's counsel has not been contacted by any member of the public agency in question or any other person named Lorianne Barnhart in this matter whatsoever. So docket 27, I understand the impulse, but you need to understand what type of person he is. Oh, that's Brown to Lorianne in the emails. Can you please talk with me before you do anything? I understand this is very stressful. So those are all in the, all in it. And then this is Lorianne saying, someone is talking to me on a sock account telling me not to trust Saltzy. There it is. Somebody's calling him Saltzy. I feel seen. Mr. Brown concealed his communications with Ms. Barnhart. I have reviewed numerous emails between Brown and Barnhart dating as early as December 24th, 2020. Brown was in contact with Barnhart when plaintiff's counsel was seeking court intervention to issue a subpoena for Barnhart's newly deleted social media accounts. Mr. Brown failed to disclose that he intended to represent Barnhart for even a limited purpose, let alone that he was in contact with her. Again, making all of this unnecessary. But okay, we're going to take the hardest route possible. Ms. Barnhart's competence and credibility were of no concern to Mr. Brown, as demonstrated by his attempt to procure a declaration from her. Yep. It was only after plaintiff's counsel succeeded in obtaining a declaration from Ms. Barnhart that Mr. Brown attacked her competence and credibility. Yep. The footnotes on this are emails. Are you able to sign something this evening and send it back to me? We will be able to review a final version in an hour or so. Can you please talk with me before you do anything? I think there's been some misunderstanding. I'd like to have a chance to clear it up. We will be filing an objection today to Saltz's latest quote declaration. I'd like to include a statement from you if you are on board with that. I'd like to stand up for you by filing your declaration. If you let me, it costs you nothing. Can we please discuss this on the phone? Please talk to me. Please talk to me. Please talk to me. What the fuck happened? I really think you'd feel better if we do. You'd feel better if we talk. You should at least speak with me about it. Please talk to me. Mr. Brown also sent Ms. Barnhart an email dated January 8th stating, you're willing to sign a sworn declaration saying so. That's generally a solid indication somebody's telling the truth. Okay, those are all in the motion. Mr. Brown hid his communications with Ms. Barnhart from plaintiff's counsel, including myself, stymieing the subpoena process and offered to object to the subpoena on Ms. Barnhart's behalf to delay discovery. Right. And delaying discovery in this incident only relates to jurisdiction and only benefits KJ. It doesn't benefit Lorianne at all. She wanted to be the fuck done with it, which I get. And then they go into the phone call where the Twitter account was gone. At no time during that call did Brown inform us he was in contact with Barnhart. This admission is confirmed by Brown in the email trail that indicates he said, I spoke with Saltz today. They're planning to subpoena your Twitter because they see that you closed your account. They think there might be evidence of a connection to Katie. I did not disclose that. You and I are in touch. Saltz even complained that you threatened him via DM. I like that they're laughing. Saltz said that you threatened him. In response, it says, figures, what are your thoughts? That was in the motion. Based upon the aforementioned emails, I believe that Brown did not meet and confer in good faith regarding the parties' joint status report and discovery plan. Right, because he should have said, I'm in touch and we can just turn it over. And then there would be no need for the joint discovery plan to include all that stuff. Additionally, this caused additional expense to plaintiffs as we negotiated the terms of parties' joint status report and discovery plan, which was filed on January 4th. We went over that on the channel as well. Quickly. In the joint status report and discovery plan, the parties agreed to stay discovery, meaning hit pause, put a pin in it until this is done, pending the court's decision on defendant's motion to dismiss with a specific exception for Lorianne's accounts. On January 5th, Brown filed a stipulated order stating staying discovery pending resolution of defendant's personal jurisdiction challenge, which included the exemption. Brown also did not meet and confer regarding the stipulated order staying discovery in good faith as he was withholding material information. Look, the court's standing order requires a meet and confer, and the court is not going to like this at all because they're saying, he says in all of his motions, we met and conferred, and they're saying, but you didn't really. You faked it. And you didn't give us all the information. So it's not an actual meet and confer. An actual meet and confer is us to get shit done so we don't have to go to the court and be like, Your Honor, can you help? Y'all, the statements made in Ms. Barnhart's declaration are either undisputed or supported by documentary evidence. So they're saying, look, there's like tweets and shit that support everything that she said. The unsigned draft documents are grossly inaccurate. Shade. The labeling of first and second declarations is a misnomer. Attached to the declaration of Mr. Brown as Exhibit E is a chart of purported differences between the three draft documents transmitted to Ms. Barnhart by Mr. Brown and related correspondence juxtaposed against Brown's impressions of Barnhart's only sworn declaration. Mr. Brown's comparisons greatly mischaracterize and or misrepresent the documents. The following is a non-exhaustive list of examples of such mischaracterizations and misrepresentations. Oh my. Remember when Brown filed that chart and we were like, oh, look, another chart, because before that, Saltz and Levine had filed a chart that showed all of the times KJ had made statements on social. I'm almost out of water. That's why I have two. Hold on, we're going to finish this one. All right. Backup water. Also, while we're doing this, can you guys do the YouTube things? Like, to the 7,000 of you that are here watching, it would be appreciated. We could thumbs up the things. We could subscribe to the things. If we're not subscribed to the things, that would be great. It would be awesome. All right. Let's just go. We might not do all these. We'll see how many there are. Again, there shouldn't be mischaracterizations of misrepresentations. There just shouldn't be any. There can be disagreements, but there shouldn't be misrepresentations. Okay. In paragraph 1 of Exhibit E, Mr. Brown states that nothing in the first draft document is inconsistent with Ms. Barnhart's 1,500-word personal statement. Paragraph 3 of the draft document discusses Ms. Barnhart's prior criminal case and falsely claims that, oh shit, it did not involve harm or threat of harm to any person. Ms. Barnhart's 1,500-word statement makes no mention of her criminal case and does not attempt to deny the public record. Likewise, paragraph 6 of the draft document states that Ms. Barnhart informed Mr. Saltz that he had disclosed the phone number and address of the wrong person. The 1,500-word statement does not, can you imagine sitting there as the attorney being like, this said this, and that said that, and this said this, and that said that. I just, oof. The 1,500-word statement does not say anything about Ms. Barnhart sending Mr. Saltz a message containing such detail. Rather, the 1,500-word statement confirms that Barnhart sent Mr. Saltz a cryptic message saying that he doxed the wrong person. We've talked about this at length because that can feel like, you doxed the wrong girl, mister. Like, don't mess with me. Versus you doxed the wrong person because there's actually another fucking human with the exact same name. I think there's two very different ways to interpret that. We've talked about that before. Paragraph 2, Mr. Brown's statement that Ms. Barnhart never objected to anything and was eager to sign the document with his office in its final form is belied by the fact Barnhart ultimately did not sign the document. Right. She was so eager that she just fucking didn't do it. Nothing Brown states with regard to paragraph 3 has any effect on Barnhart's statement that she did not tell Brown that Saltz threatened her. The statement, more threats directed at me, has the wrong date, is taken out of context, and is mischaracterized. This is going to keep going. This is a response to a direct message on January 1st, 2021 from a friend of Miss Barnhart who indicated he tries to make one think he's a friend. Further, the statement was not made to Mr. Brown. Miss Barnhart confirmed during our January 12th call, after refreshing her recollection and reviewing these direct messages once again, that she was not actually threatened. Wait a second. Brown said that she said more threats directed at me to him, but they're saying that those were statements on Twitter in response to something else. What? Okay. Mr. Brown informed Ms. Barnhart that a subpoena would be issued. Mr. Brown indicated on January 6th that Saltz threatened to add Ms. Barnhart as a party to the lawsuit. Prior to Mr. Brown's January 6th email with that false threat, the record is clear that Ms. Barnhart had never told Mr. Brown that Saltz threatened her. Rather, all other references of the word threatened that Mr. Brown claims in his declaration to exist were contained in communications after January 6th. And were then only repeated back to Brown what he falsely informed her of January 6th. So they're saying Brown told Lorianne they're threatening to add you to the lawsuit. And Lorianne just went, oh, are they threatening me again? Oh, goodness. Nowhere in the 1,500-word statement sent prior to January 6th did Barnhart state therein that Mr. Saltz threatened her. The email from Barnhart that prompted Mr. Brown's response informed Mr. Brown that Mr. Saltz had only stated Miss Barnhart was being added to the witness list or something, which is not being added to the lawsuit. But I could understand the difference, because if you are an attorney, being on the witness list is like, oh, you're on the witness list. I can see how to a person who is not an attorney, it would be like, you're adding me to this lawsuit. Like, being on the witness list feels like I'm in the lawsuit. To lawyers, being in the lawsuit means you are the plaintiff or you are the defendant. You are a party in the lawsuit. But I could see the reasonable interpretation that somebody else went, being on the witness list means I'm in this lawsuit. Like, I don't want to be in the lawsuit. I don't want to be in the lawsuit. I don't want to be in the lawsuit. I can understand that. But Brown seems to be fanning the flames of that. Brown then mentioned the word threatened to Barnhart for the first time in response to Ms. Barnhart stating, yeah, he threatened to add you to the lawsuit. So that came from Brown, who fucking knows better. Brown knows they're not threatening to add her to the lawsuit. If they're saying they're going to add her to the witness list or subpoena her, that's not adding someone to the lawsuit. Lay people, non-legal people, muggles, legal muggles don't know that. Lawyers know the difference. Jesus. I hate this so much. Mr. Brown also cites that there's no such, also cites to page 146 in docket 52, but there's no such page. Shit. He's citing the shit that's not there. He's filing motions that can't be filed, and he's citing the shit that doesn't exist. There were no threats made by Mr. Saltz to Ms. Barnhart. Subsequently, Brown sent an email stating, it would be great if you could state that you took it as a threat and felt threatened. I hate that line so much. That's the thing that turned, look, I didn't like the motion to dismiss, but sometimes I understand that lawyers follow what their clients want, and I get it. This line is what had me done with the way Brown was doing things. It wasn't even the mentioning of the me. It was, if you could state you could take it as a threat and felt intimidated, yeah, that would be great. That is where I was out. That shit pisses me off. You don't do that. That is not okay. Look, as a former district attorney, this shit would not only be on the front page of the paper, but as a DA doing shit like this, will absolutely get you fired, could get you prosecuted for prosecutorial misconduct, and might get you disbarred. Now, in civil, it might not be as serious as all that, but my reaction is strong nonetheless. And it's in an email. In 4 of Exhibit E, Brown is asking the court to discount a sworn declaration instead rely on the unsigned draft. Yeah, we know that. These statements were made at a time in which Ms. Barnhart did not have access to her Twitter account to refresh her recollection. Additionally, Ms. Brown did not ask Ms. Barnhart to reinstate her Twitter account so he could review to verify the accuracy of these statements. Wait, so he's asking her to say, oh, but this was said on Twitter while she wasn't looking at Twitter? How many of you remember exactly verbatim what was said? I don't. You have to go look at it. Additionally, Mr. Brown did not ask Ms. Barnhart to reinstate. In contrast, Saltz did have Barnhart reinstate her Twitter and spent several hours with her reviewing several hundred interactions between her and Paulson. In reviewing these interactions, Saltz noticed public tweets wherein Ms. Paulson had asked Ms. Barnhart to perform tasks on her behalf. Oh, fucking hell. This caused Mr. Saltz to inquire further about Ms. Barnhart's interactions with Ms. Paulson, which sparked a specific set of memories regarding Ms. Paulson asking Ms. Barnhart to issue negative reports on the YouTube videos of some of Ms. Paulson's competitors. There's that. That sure is in that declaration. Yikes. And see, look, again, if Brown hadn't filed this, none of this would be coming up going, well, this is why she knows it's true, and this is why she knows it's true, and this is why she knows it's true. Fuck. Brown states that Barnhart's statement that Paulson knew she lived in Washington is inconsistent with statements in her various draft documents. Ms. Barnhart's 15-word statements told Mr. Brown, I reached out to her around April and told her my life story. In addition, Ms. Barnhart informed Mr. Brown that she was Facebook friends with Paulson. This is significant because had Mr. Brown performed his due diligence, had you done your job, boo, he would have learned that Ms. Barnhart's Facebook account displayed her state of residence in Washington. So this is getting into the fact that, hey, Brown, you were going to have her sign this declaration, but you didn't even know if any of this shit was true. Look at all the work we did to prove the shit was true. Fuck. Mr. Brown matches up 2 consistent Exhibit E, Mr. Brown matches up 2 consistent statements. Additionally, Mr. Brown did not have the benefit of the Twitter account when drafting the statements. Mr. Brown fails to account for the fact that during the interview of Barnhart, Saltz interviewed her about the 1,500-word statement and asked Barnhart by which method did she share with Ms. Paulson her life story. Barnhart then remembered that she did it in a lengthy email to Paulson, which Paulson also replied via email. This is going on and on and on. Oh my God. Okay. Because we're on page 15 of 58. Oh, okay. During the telephonic conversation, Barnhart stated that she did not trust Mr. Brown because she expressly told him that it was incredibly important to her that the error in the Fulmer declaration be corrected immediately. She stated that she expected Brown to contact Saltz at the earliest possible moment to advise him of the error so that Saltz would know to file something with the court to correct it. Barnhart then said her mistrust in Brown grew over the next 3 weeks, wherein she would continuously prod Brown, we saw that in those emails, as to whether the issue had been addressed. All trust broke down when it became apparent that Brown was not going to contact plaintiff's counsel. Fair. Brown's statements are not inconsistent with the signed declaration. Brown's statements that Barnhart was eager to sign a document with his office in its final form is belied by the fact that she actually didn't sign it. Fair. Oh, we're almost done. Okay. We're almost done with this part. Brown attempts to change the words of paragraph 28 of Barnhart's declaration and cites to a document that does not say what Mr. Brown states it says. That does not say what you think it says. That comes up a lot with him. As stated above, Brown's draft declarations are contradicted by the 1,500-word statements and the cryptic message Ms. Barnhart sent to Saltz. That's you doxed the wrong person. Mr. Brown had evidence that the statements in his draft documents were incorrect. Ms. Barnhart only sent Mr. Saltz cryptic messages. So this is going on and on and on about that. Brown's attempt to procure Brown's attempt to procure false testimony from Barnhart. That's the reverse right there. It's like, oh, 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 oh. You want sanctions against us, Brown. But let's just take a look at what you've done to procure false testimony, because we have receipts attached and the receipts say what the fuck they say. What you're saying, where are the receipts? Holy shit. This isn't, you guys, I did not expect. This is not what I expected. I'm pleasantly surprised, but this is not what I expected. On January 6th, Brown transmitted 3 versions of the draft declaration to Barnhart for her review, all of which had false statements contained therein and are contradicted by the written record provided by Barnhart and the declaration of Kim Fulmer. For instance, paragraphs 2 and 3 of the draft documents transmitted by Brown to Barnhart contained false statements regarding purported interactions between Saltz and Barnhart. Okay, that's just, I'll cite back to it. Specifically, the false statements are that the declaration of Fulmer was an effort to follow through on a public threat he directed at me on Twitter on November 2020. And Mr. Saltz responded by publicly threatening to make me a defendant in this case. Did anyone see that happen publicly? Because I sure didn't. There was no such threat. Instead, because if it was on Twitter, it'd be in 900 videos. It would be in all of the videos. If that was said, there would be videos. Mr. Saltz responded by publicly threatening to make me a defendant in this case. Instead, as stated above, Barnhart told Brown, remember when the court said, what I don't want y'all doing is going back and forth? Remember that? I missed that. But the shade in this is kind of marvelous. Instead, as stated above, Lorianne told Brown that Saltzy was soliciting information on Twitter, which he was soliciting information on Twitter. That's exactly what the fuck he was doing. And that Saltzy was going to add Barnhart to a witness list, which is different. The only threats were the fake threats invented by Brown. They've gone all the way in. They've gone all the way in. When I said I didn't know how strongly they were going in. Gone in. The only threats were the fake threats invented by Brown on January 6th to scare Miss Barnhart into falsely believing that Saltz was threatening to add her to the lawsuit. That is fucking crazy. All mentions of such threats by Miss Barnhart to Mr. Brown were after the January 6th email. We covered that. So Brown said, Saltz is threatening to add you to the lawsuit. That's where that came from Brown. You guys, this is insanity. Paragraph 3 of the draft declaration transmitted by Brown to Barnhart contain false statements regarding the nature of Barnhart's criminal offense, which is a matter of public record and was equally available to Brown. Subtext, had he cared to look at it, to confirm the context of said record. The draft documents state that Barnhart's criminal case did not, quote, involve harm or threat of harm to a person. Additionally, Barnhart discussed her criminal matter with Mr. Brown, yet he misstated. Wait, so Lorianne told Brown what it was, what was, and then he still misstated it. Yay. So Lorianne told them, hey, I told Saltz it's this. And then, or I told Brown it's this. And then Brown still put in the documents, not that. That's not okay. Additionally, Barnhart discussed her criminal matter with Mr. Brown, yet he misstated the nature of the criminal case in the draft documents. Paragraph 9 of the draft documents contains the following false statement, unsupported by evidence. Quote, I informed Mr. Saltz shortly after the filing of the Fulmer declaration that he had disclosed the phone number and email address, the wrong person. As stated above, nowhere in the record does it indicate that Ms. Barnhart informed Saltz that he had disclosed the phone number and email address of the wrong person. We've talked about that. This is the other statement, quote, my interactions with Paulson have been limited to 1, a few brief online conversations unrelated to this matter. 2, the fact that I was a subscriber of her channel for a brief time in 2020. 3, the fact that last week I sent her a few chats super chats. And Miss Paulson and I have never been friends and have had very little direct contact. I have not done anything to coordinate with her to, quote, hide evidence or do anything unlawful. That part might be true. Nor did I have any reason to believe that she would want me to do so. I don't know if that's true. I have no reason to believe Miss Paulson knew what state I lived in until very recently. Oh, it binged. Thanks, y'all. You're doing the YouTubey things because it told me so. I appreciate it. Thank you. First, paragraph 11 of the draft documents are false in regard to the statement that Miss Barnhart does not have any reason to believe Miss Paulson knew where she lived. She told her life story. Wait until we see the life story is just like, she didn't tell me her whole life story. Like I'm interested to see how that gets spun down the road. Second, Mr. Brown's attempt to have Miss Barnhart diminish her connection to Paulson is an attempt to create a false narrative. It's a false narrative. Somebody's running a narrative. Somebody's running a narrative, and Elana Levine just said, Brown, it's you. You are running a narrative all up in this lawsuit, and we're not having it. Wow. Okay. Brown knew Barnhart had deleted her Twitter account and did not ask her to reinstate it so he could verify the interactions between her and Paulson. Without actually reviewing Miss Barnhart's Twitter account containing hundreds of interactions between... Do we think Brown's ever looked at anything in this case? Has he watched any of the videos? Has he looked at any of the tweets? Do we think at this point he has looked at anything? Because I have questions. Brown asked Barnhart whether she would be willing to file a statement that just says you're not that Lori and your contact with KJ was limited. Brown did not attest that he actually went over the context of the draft document word by word, line by line, paragraph by paragraph, as plaintiff's counsel did. It's like, look, we did the work. You didn't. Oh, the conference call. Oh, let's talk about what happened on that phone call. Fascinated. On or about January 27th, 2021, I attended a telephonic conference call requested by Brown that lasted a total of 40 minutes, not 1 hour, as stated by Brown's time records. See, and when lawyers do timekeeping, they tend to keep it down to like 5 to 7 minute increments, sometimes 10. But see, they have the billing records because Brown put the billing records in the other motion. And they're like, no, it was 40 minutes. It's just like every single little misstatement. This makes not only the judge mistrust an attorney, but the research attorney. Like that first page where it's like, he said this to the court on the phone and it actually says this is going to really harm the court's trust in this attorney. But going through this, the court is going to be like, what is actually happening? Like, okay, so even the billing records show an hour is being charged when it was a 40-minute call. You guys, this is bad. The conference call was supposed to be regarding the following 4 anticipated motions to be brought by Brown. 4. Motion for sanctions, motion for Rule 11 sanctions, motion to shorten time. I bet if they had gotten to that, do you think Saltz would have said, actually, you can't do that? Or do you think he would have just been like, bro, we owe you no favors. You go ahead and you file that. You go ahead and you file that motion to shorten time and you see what happens. And we saw what happened. The court was like, you can't do that. Motion to qualify Brown to continue to represent defendants. Mr. Brown's entire recantation of said discussions during the meet and confer is false. Wow. During our limited discussion about the motion for sanctions, Brown questioned various aspects of the signed declaration. Saltz told Brown that during the call that Barnhart takes medication on occasion for her personal health. Saltz explained that the side effect of the medication makes her foggy. Saltz explained to Brown that Lorianne had advised us that after speaking for approximately 11 hours, she took medication. Saltz told Brown that this caused us to adjourn our call on January 12th and pick back up the next day. No one told Mr. Brown that Miss Barnhart told him a false story. Additionally, contrary to his statement in paragraph 5 of his declaration, no one told Brown that we rushed to complete the interview, right? That was all Brown speculation. but you can't speculate and say that they said it. With Barnhart to obtain her signature. Instead, Saltz told Brown that Barnhart sought to correct the public record as quickly as possible because after 3 weeks of communications with Brown, he had not dealt with the issue. Saltz told Brown that he was more than willing to share the documents that our office reviewed in drafting the declaration. I bet that courtesy is not going to happen anymore. Brown did not follow up with Mr. Saltz's offer before filing his motions for sanctions. So he didn't even want to look at the shit, is what they're saying. Like, you didn't even want to look to see if the receipts are accurate. Although we had not finished substantively discussing the issues, after 40 minutes, Brown indicated that his associate needed to depart the call, so we cut the call short. Well, who's the associate that's like, bruh, gotta bounce? I can't imagine. We did not complete the meet and confer process as to the other potential motions that Brown indicated he wanted to bring. At the conclusion of the call, Brown did not attempt to reschedule. During the call, Brown asked about the, quote, mass flagging, interesting, referenced in the declaration. I informed Brown that there were videos made about the defendant instructing other, YouTube-y things, instructing others to flag other YouTube channels in violation of terms of service. Subsequent to the call, I sent Brown a link to one of those videos. God, I'm curious to know which one, which corroborated Ms. Barnhart's testimony on the matter, and Brown thanked me. However, Brown pressed forward with his motion for sanctions, ignoring the evidence that we provided to him during the call. I love that YouTube's evidence now. Like, this is the world we're living in. I live. Insisting that the entire declaration of Barnhart is still false. Like, just parse it and be like, okay, well, this part's not false, but that part seems false. And refusing to meet and confer to go over the documents. They offered to say, here are the receipts. Motion granted. Motion granted. Queen Levine it is. Saltzy and Queen Levine. I love this. Granted. All right. We're only on page 22 of 58. Are receipts attached? Receipts! Oh, this is all of those emails that were already... Oh, no, these are the ones they're saying that Brown left out. Okay. I'm waiting to hear back from the lawyer for the other Lori still. Would you be willing to file a statement? This wasn't filed by him. Interesting. Would you be willing to file a statement that just says you're not that Lori and your contact with KJ was limited to a few chats? You could also explain why you sent those tweets to Kim. It might be good to get your side of the story, quote, out there. Okay, I'll send the draft declaration in the morning. Will you be around tomorrow to review it? I spoke with Saltz today. They're planning to subpoena your Twitter. We've already seen that one. Sure, what time? Can you talk today? Those ones were not about Saltzy, though. But they are helpful. Do you have other screenshots of Lorianne sending money to KJ in any vids? This was him literally seeking evidence. Do you have any idea why they are targeting me? I haven't done anything besides defend myself and others. Oh, sweetie, they're not targeting you. You live in Washington. I was watching a live of KJ today. I could not join her channel. The link wasn't working, so I sent her super chats. My Twitter account is gone. I'm trying to get away from these people. I can understand that. Anytime I do anything, they post it, just FYI. So these are the screenshots. Lorianne's super chat about you. So these are the things on Twitter that were screenshots. Do you know or have screenshots? Okay. Exhibit 2. Oh, there's a table. Table of statements from Barnhart's declaration. We saw a table of KJ's statements, and then we saw Brown's table. Now we have another table. This looks like it's linking every statement in the declaration to prior statements or to actual receipts. We're not reading this whole thing. I will read this before Friday Night Live, but we're gonna take a perusal. We're gonna cruise, but this is literally the receipts. This is a table of receipts. Table of receipts. You've done it wrong, Queen Levine. Table of receipts from Barnhart's declaration. Receipts. All right, table of receipts. Receipts. Oh, I'm dead. Hold on. Let me pull this up. Let me pull it up. Let me pull it up. The boom. It's the boom for me. I'm dead. Wait, are these all the conversations between KJ and Lori? Oh my God. It's probably Kim and one of her fake accounts. So these are from earlier. This is before I knew who anybody was, because I came into this whole story when the lawsuit was filed on Halloween. I was unaware of the existence of any of this before then. Oh my. Okay, so here's all the interactions between them, showing it's more than a few. Boom. Are there more? Oh, there's more. Oh, these will be fun to read. We're just going to have to do it at another time. So that was March. These are April. This is April. Lori. If you follow me from a protected account and tweet at me, I can't see you. Yes, we know how that works. This is May. Oh, Lori, I adore you. You know that doesn't change. I actually follow you, Lori. I can't see Kathy's response, what Joe is doing right now. I adore you. Okay. I don't know her. Remember the I don't know her? Lori, I adore you. Okay. Are there more? Yep. There's more. Wait, what are these? Oh, the DMs. Hello, Nate the lawyer. I see your face there. And this is the one where Lori's down here. I remember that. I just blew up the receipts. Like, we don't even need to know what they go to at this point, because we've read that declaration at least twice. The screenshots are the most fun. My fiercest and loyalist next to Bloodtall. That's Lorianne. Oh, this is the Sanders Kennedy situation. Don't worry. You and Lori will be on the hunt. What? I saw Sanders Kennedy video first. I don't understand why everyone is coming after you when you didn't release the information. It looks like they were all ready to take you down. Oh, she does talk about the Sanders Kennedy video. Don't worry. You and Lori will be on the hunt. On the hunt for what? Are they going troll hunting? I think so. Consistent statement, Facebook friends. I love that they've put the other consistent statements. I want more screenshots, though. They're the most fun. Do you blame her? Send me your pic so I can blow it up and pick you apart. Let me judge your parenting, your marriage. A person can only take so much. Her guard is up, but it is coming down. Let her know this is why she's blocked, because I know she's trolling. That was asking her to do things. That was in the other declaration. This was text screenshot of Sherelle's World flagging. Have we seen this before? I don't think we've seen this before. I want to make sure I have the correct definition of mass flagging. I think that means she told me to report Sherelle's World myself. I did report it, but I didn't tell or ask anyone else to. Do I have it right? I hope so. I hope I don't add myself to the lawsuit. No, thank you so much. I was worried. But who? As to the private instruction, Ms. Paulson admits to flagging certain channels and to private conversations with Barnhart's, a person to whom she previously stated she has no previous connection with. Specifically, in Paulson's second declaration in support of defendant's motion to dismiss, Ms. Paulson admits that this conversation took place with the caveat that she only instructed Barnhart how to flag Sherelle's video, not necessarily to flag Sherelle's video, which appears to be distinct without much of a difference. Furthermore, due to the above video's documentation of Paulson's long and unenviable history of soliciting mass flagging, it appears to plaintiffs that Ms. Paulson's attempt to distinguish her version of said conversation between herself and Ms. Barnhart is at best dubious. Oh, so this is DMs between Lori and KJ. Interesting. Again, none of this would have come in. None of this would have come in if Brown had called Saltz and been like, yo, it's the wrong Lorianne. Can we file a stipulation? Literally none of it. Oof. More screenshots. Between Lorianne and Julie Virgo. About Katie, it looks like. Katie is bad, but she isn't a serial killer. I'm curious as to what the rest of the conversation is about. Uni would be better off without Katie. He's lost subs over her and she treats him bad. I no longer support them. Katie cares about Katie. I'm just one sub, so my thoughts don't really matter. I just observe and try to keep my opinions to myself. When was this? Oh, this was September 2020. So this is like right before this all went down. I can see the legit criticisms. I personally can no longer support her. I voice my opinion here and there, but there is so much negativity in this world. It can be exhausting. She will do herself in before long. I can't say much because I myself have said a lot of mean things, which I take full responsibility for, but that doesn't make it excusable. I see it all now. I don't know why they did that last night. It certainly isn't going to help the situation. These are in August. Lori, I adore you. That came up again. Specifically on August 14th, a creator named Unirock. Hi, Unirock. Posted a live stream video called Live Scope with Katie without a crystal ball. At approximately 56 minutes, Ms. Paulson says, Lori is so mad at me for literally trying to end drama with, I'm so disappointed in you, Lori. I am with Leslie, but I have to do this for myself and I have to move forward. And just like I can't stay mad at Kyle forever. Who's Kyle? Can somebody let me know who Kyle is? At Kyle forever, actually a good friend of mine. I was friendly with Leslie. I don't know why anyone wants to perpetuate this drama. At approximately 70 minutes into the video, Ms. Paulson says, this proves my point. Now Lori is saying that certain other people are looking better every day. Remarkably, Ms. Paulson is so familiar and connected with Miss Barnhart that she can spot when someone is trying to pretend to be Miss Barnhart and recognize which person is the, quote, real Lorianne and which one is the fake Lorianne. Once again, will the real Lorianne please stand up? Like, all the tea is buried in this chart. And in a Unirock video, apparently. All right. At approximately 78 minutes in the video, Ms. Paulson states there's 2 Loriannes in here. There's someone that's fake. There's a lot of Loriannes apparently. Also see 100K celebration stream. That's the one where I think she calls Lorianne her best friend. Oh, this one, Lori. Don't ever get into it with Lori. Lori remembers your names. Lori is the catalog. Lori didn't like me at one point, and now she's my best friend. That was in one of the other declarations. Oh, and here's a Dropbox to it. Oh, this is the beef between Lori and Saltzy when she was on Twitter saying Saltzy's not a professional. I remember that. More screenshots of the interactions between the two of them. There is so much stuff. And that's the point. The point is that all of this came up literally because KJ put in her declaration, I have 0 subs, which again, you never want to say you have 0 of anything unless you don't know, unless like you really know. There's analytics that show it. Like that should have never been in that declaration in the first part, because it can't possibly be true that not a single person from a state has ever watched a video on a YouTube channel, and it just gives fodder. And now we're here. And now we're here with DMs of requests for mass flagging, which isn't a good look. I don't know why that's being strange. Okay, let's see what else is in here. This is more about the Unirock scope, like Periscope, I'm guessing. How many pages is this chart? This was in the motion. This was Kim Fulmer and Lorianne chatting. We're not going through this whole chart. We're on page 52 of 58. So the rest of this is just this chart. Let me see why that won't recover. My, apparently, I'm going to refresh this real quick because my computer's tired of this shit. It's just like, nope. And I'm like, no, but we need the receipts. Let's get to the bottom of the receipts. All right, let's get to the end of these receipts. And then we still haven't gotten to Saltz's declaration yet, and we're over 2 hours in, but y'all, come on, PDF. Don't let me down now. We still haven't even gotten to talk to the chat yet. We've got stuff to do. Okay. The rest of Elana's declaration is just more receipts showing where there's consistent statements. So that means what's next is Saltzy's declaration. So we're going to keep rolling, guys. This is a good time to say, by the way, there are over 7,000 of you in here. Do the YouTube things. I appreciate it. The liking, the subscribing, the thumbs upping. Share this with any creators that are also talking about this if they need the legal background. Let's get into Saltzy's declaration. Page 1 of 49. Please let it be pictures. Like, I'm at the part of class where I'm like, please let the rest of this assignment be photos. Please let it be pictures. Please don't let it all be text. That's the part we're at. But I'm waiting to see what Saltzy has to say. Let's see if anyone's washing their hair in this declaration. All right. Now we're done with Queen Levine's declaration. Let's get into Saltzy's declaration. Attorney, Pro Hoc Vice, initial interactions with Ms. Barnhart. Oh, we're going to hear more about this. Prior to filing the complaint in this case, I personally had never heard of Lori Ann Barnhart. I mean, same. However, shortly after filing of said lawsuit, Ms. Barnhart took to Twitter on or about November 4th and accused me of being an imposter and that impersonating an attorney was a crime. I responded by telling her I was, in fact, a real attorney. I mean... I am a real attorney. I was going to do the not a cat, but the cat's not pulled up. Darn it. It would have been funnier. But my cat is not pulled up. I am a real attorney. I am here live. I am not the cat. I am not the cat. We're going to try it one more time because it's the perfect opportunity, but your girl wasn't ready. I'm a real attorney. I am not a cat. You can come to my office and meet me in our legal team. Ms. Barnhart wrote back that she was of the belief that professionals were not on Twitter. No, they're cats on Zoom calls. I responded to Ms. Barnhart that my address, email address, and telephone numbers were on the pleadings, of which she had tweeted a copy, and that my invitation to come meet us and collect evidence stands. I am a real attorney, even though I am on Twitter. Okay, I'll distract myself. I had to assure her that I am not a cat. Had to be said. It had to be said. Ms. Barnhart then wrote back that I should thank her for sharing my information since my Twitter account is not verified. And I am followed by random accounts with unusual names. I mean, they don't just verify lawyers on social media. They don't just be like, oh, you're a lawyer, verified. Like, that doesn't happen. You have to chase that blue check mark. Like, that shit doesn't just come. You don't just get the blue check mark. I got distracted by blue check marks. Okay. I should thank her. I love that Lori Ann's like, well, you should thank me because you're not verified and I've just verified you. Sweet. I then thank her for believing in us. Ms. Barnhart then responded that I should get Twitter to verify my account. Yeah, that's not how that works. I then responded to Ms. Barnhart that I did not personally know how to get a Twitter account verified. Same. Twitter, we'd love to know. So curious. But I would not be opposed to it. I also asked Ms. Barnhart if she knew how I could start the verification process, and Ms. Barnhart said she did not. I'm dead. Like, hey, Lori Ann, can you get my Twitter account verified? Below are true and correct screenshots of this initial interaction. The receipts. All right, we've already done that. You can thank me for sharing your information. Thanks, Lori Ann. I don't know why that's so funny to me, but that's hilarious. I'm not anyone that needs to be verified. That's funny. At no time during this interaction did I threaten Ms. Barnhart and tell her that we were going to make her a party to this lawsuit. In fact, it was my understanding that Ms. Barnhart's Twitter attacks aimed at myself had been diffused after our conversation ended in a collegial and courteous manner. I have never stated or threatened that I would add Ms. Barnhart to the lawsuit. The Kim Fulmer declaration. We're moving right along. Saltzy's like, let's go, let's go, let's go, let's go, let's go. After the Twitter interaction with Miss Barnhart, I began to look into Miss Barnhart. I eventually learned that Miss Barnhart was a longtime supporter of Miss Paulson and that she lived in the state of Washington. And you know, when Saltzy discovered that, he was like, whoop, there it is. You're going to say you've got nobody in Washington. She's a paid member of your account and she's in Washington. All of which would be irrelevant if you hadn't made a motion to dismiss based on jurisdiction, but that is their right. I'm not mad at the motion to dismiss because of jurisdiction. I'm mad at the way it was written on 45-line paper and talked about nothing but bye, sister. But let's keep going. Below is a true and correct copy of redacted screenshots from Twitter making said then unrebutted. That's awkward. Making then said unrebutted claim that Miss Barnhart, who went by the Twitter handle Bloodtall, was an employee of a state agency. Professionals aren't on Twitter, LOL. Well, Miss Barnhart is supposed to be a professional herself. She's an employee of the Washington Dot, which is a government agency, and yet here she is conducting herself like a child. This information became relevant after Miss Paulson filed a motion to dismiss for lack of jurisdiction. You can't be the boss of me, which was accompanied by a sworn declaration from Ms. Paulson containing the following statements. To my knowledge, neither I nor Without a Crystal Ball have any sponsors or subscribers in Washington. To my knowledge, neither I nor WACB derive any income from the state of Washington. Again, you lost it for yourself. This in the declaration literally is why all of this popped off. I don't understand why an attorney was like, aren't there analytics? Can't we see this information? Like, is this true? How do we know that there are no subscribers in Washington? Oof. In or about December 2020, I was informed by a former moderator of Miss Paulson's video chats. They're live streams. Live streams. Kim Fulmer, that Miss Barnhart had previously threatened her purportedly due to a related dispute Miss Fulmer had with KJ. I was informed that Fulmer investigated Barnhart and found that Barnhart was a resident from the state of Washington, had a public Washington criminal record, and that Miss Barnhart's name appeared on a publicly available list of state agency employees, which, after somebody said this on Twitter, I can understand being like, right, it's the same person. Fulmer's inclusion of the top page of the charging documents in her declaration was for the purpose of establishing, 1, that Miss Barnhart is a Washington resident, 2, Fulmer stated fear for her safety. This is in the motion because they're saying that Saltzy put that in for an improper purpose. Like, he put it in just to be a dick, but like in a legal way that he should be sanctioned for. And he's saying, no, Kim Fulmer put it in her declaration because of this reason. So as long as there's some valid reason, I can't be sanctioned. And this is some valid reason. Like, it just is. I cannot say much because I myself have said a lot of mean things, which again, people do shitty things on Twitter, but I understand that Lorianne was also like, but I don't want the other Lorianne to have to like cash those checks. That's why I think she wanted to fix it so badly. But I talked about that in the other video about that declaration, and then about the 300-page declaration from Brown that we read. Message from Miss Barnhart after the Fulmer declaration. The day after the Fulmer declaration was filed on December 24th, I received an unsolicited direct message to my Twitter account from Barnhart. Barnhart never told me that she did not work for any state agency, or that Miss Fulmer incorrectly stated that she did. Miss Barnhart sent me another direct message on December 25th, which was cryptic in nature and was taken by me as a threat rather than as a notice that any information in the Fulmer declaration was inaccurate. Let's hit this footnote and then get to the pictures. Despite Mr. Brown's attempts to have Miss Barnhart sign a declaration falsely attesting to contrary facts that her criminal case did not involve harm or threat of harm to any person, or that it was dismissed for lack of merit, the affidavit for probable cause confirms otherwise. Plaintiffs, however, do not wish to attach said public record as an exhibit in these proceedings due to the personal nature of the facts contained therein. However, if necessary, said affidavit will be made available for this court's review upon request. The affidavit would have the nature of whatever the thing she was charged with in it, like the kind of nitty-gritty of it and the details of it. Nevertheless, said affidavit is public record and was equally available to Mr. Brown to review before he attempted to have Ms. Barnhart sign a declaration falsely attesting to its contents under penalty of perjury. Ugh. In the December 25th message, Merry Christmas. You doxed the wrong person again. You will hear about it next week. However, no further detail was ever provided by Ms. Barnhart with regard to what was meant by said message, and Ms. Barnhart never clarified that she did not work for a state agency. I did not respond to Barnhart's message as she had instructed me not to. Likewise, prior to receiving said messages, I had made no effort to contact Ms. Barnhart after responding to her efforts to initiate contact with me on Twitter in early November. So these are the screenshots. You and Kim Thormler doxed the wrong person again. You'll hear about it next week. Please stop harassing me. I've already asked you to leave me alone. These screenshots are just a very small amount. I was harassed by about 30 people just because I stood up for her. Damn right, I will stand up for myself and my fault, just like anyone else would. My fault, my friend. I don't know what that means. If anyone in my family is harassed because you have doxed me out of malice and nothing more, it will be on you. False accusations aren't cute. But then again, it looks like she's saying that that's her information. I get it. Barnhart expressly informed Brown several times that she had privated her Twitter account and that only people she followed on Twitter could view her postings on her Twitter page. Prior to January 12th, Barnhart never informed me, and I did not know that the Lori Ann Barnhart identified by Ms. Fulmer as working at a state agency was not this Lori Ann Barnhart. I think it's funny that they say the real one. It's like, no, it's just not this one. It's not the one that subscribed to KJ. It is another one. My January 4th declaration after the timely filing. Is that shade? Is that shade? Is that just like, we did it right? After the timely filing of plaintiff's opposition papers to defendant's motion to dismiss, Paulson posted on social media a false narrative about her connection to Ms. Barnhart. One specific tweet purportedly published by Ms. Paulson on December 3rd, 2020 to the public responded to the contents of plaintiff's opposition papers stating, I have no connection to Lori Ann. We saw the screenshots in Queen Levine's declaration. Below is a true and correct copy. However, at the time of said tweet, our office was already investigating evidence that had come to light on the evening of December 29th because of KJ's live stream, that Ms. Barnhart's connection with Ms. Paulson was more significant than what Ms. Fulmer attested in her declaration. This included, but was not limited to, the fact that Ms. Barnhart had been a paid member of Ms. Paulson's YouTube channels, a fact which otherwise appears to directly negate Ms. Paulson's previous statements to this court that she does not derive any income from Washington. What is more, on or about December 29th, Ms. Barnhart deleted all of her social media accounts, thus effectively obliterating any and all public displays of Ms. Barnhart's connection to Ms. Paulson and all direct messages on Twitter that Barnhart had with Ms. Paulson, which you can see why it would be stressful, because it would be like, we need those if it's going to go to personal jurisdiction. The DMs are important. The DMs are very important. So it is my personal experience that direct messages on Twitter delete and disappear from my account whenever the account with whom I've communicated with deactivates their account. This means that the act of deactivating Ms. Barnhart's account not only obliterated her Twitter direct message conversations with me, but would have obliterated her Twitter direct messages conversations with Ms. Paulson. On December 30th, 2020, I participated in a meet and confer with Brown, Queen Levine. Ms. Kaplan was also in attendance during the call. I explained to Brown that Barnhart had deleted all her social media accounts the night before. I also explained to Mr. Brown that we are aware that Ms. Paulson had communicated directly with Ms. Barnhart on Twitter, and that if we do not get Twitter to preserve the data within 30 days, it'll be deleted. All of the data from Barnhart's account becomes permanently unavailable. We've seen that in the motion. DMs. On January 1st, 2021, I noticed a tweet wherein a person using a Twitter account belonging to someone I will simply identify as Ms. G was stating that she had lost contact with Barnhart and was concerned about her. I responded to G privately in a direct message. These were included in the other motion. I pray that you're looking out for Lorianne. She suddenly blocked me yesterday. I'm really worried about her. So this is just conversation after the Fulmer declaration came out. At no time did I intend to threaten G or Barnhart in these communications. In fact, G confirmed that her perception of the conversation was that I was trying to be a friend by which by definition is not threatening. Tell me that the footnote is the definition of friend. He tries to make one think he's a friend. Well, that's not saying that she thought you were a friend. That's saying that she thought you were trying to make it seem like she was a friend. After Miss Barnhart's signed declaration was filed with this court, and during a time period I had been granted access to Barnhart's Twitter account to document messages and tweets, I received a direct message from G to Barnhart in which G stated that Brown attempted to get G to sign a declaration accusing me, Saltzy, of harassment. Holy shit. So Brown's trying to get this woman to, this person to sign a declaration, and this person's DMing Lorianne at the same time when Lorianne's like, no, go ahead, log in. You can look at my Twitter. Yikes. You're going to be okay. Sorry for being so cold. We've not seen these before. I felt betrayed. I was trying to help you. When you said you talked to Saltz, I told Michael that's why my declaration would not have worked. It would have looked like I lied when I said Saltz harassed you and you feared him. I feel the worst is behind you. She used you. She said all of that about Tati. She lied, doxed, and manipulated so many. If she has to pay, so be it. Holy shit. She accused me of playing games and deliberately putting off signing the declaration. Nasty bitch. So cold. Do you understand? I wasn't trying to help Katie. I don't give two shits about her. She wasn't my friend ever. You are my friend. Oh, watching your declaration on Emily Baker. Hi. Didn't realize it was out. I feel dumb. So fucking glad I did not get involved legally. I'm sure everyone is at this point. I understand. It's hard with these blacked out to see who's talking to who, but that's what those DMs said. Oh, there's more. Her attorney kept wanting more information. I couldn't provide proof. Thank you, Jesus. He said he never wanted another YouTube case. I can understand that. Not everyone's prepared for what this world is like. I'm going back into hiding so I can take care of myself, get rid of toxic energy. Always a good plan. They tried to get me to do a different declaration. I told them no. Wow. 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 Ms. Barnhart contacted plaintiff's counsel on January 10th, approximately 7:54, just 2 minutes after Ms. Barnhart called Brown a slime ball in an email. Barnhart sent me a series of direct messages on my Twitter account from an alternate account belonging to her. In these messages, she gave me her phone number and said that she sees what is happening now and invited me to call her. She said that she had previously called Brown and said that she got sucked in and believed him too. She said that she had no problem giving me access to her social media accounts and that she did not have anything to hide. She apologized for previously being rude to me and stated that she would answer any questions that we have below our true and correct. I'm kind of living for all the screenshots of the DMs. I'm just going to be perfectly honest because it's said what is said. Said what is said. This is Lori. You can call me if you like. I see what's happening now. They left in the 425 because Washington, I think. I have no problem giving you access to my Twitter, Instagram. I don't use Snapchat. Same, girl, same. My Instagram is just a sock account I used to watch Instagram live videos, but you can have it. I felt I was being harassed since my post on May 2nd. I don't recall making any threats, but you can look. The worst stuff about me is everything Real Housewife gave you. I did say if people kept at me, I have people that will stick up for me. So everyone turned their focus on me and tried to entice me to say or do something. They wanted me to lash out. I could never figure out why everyone wanted to be my friend and why I had so many people wanting to follow me. Wow, I've been the idiot this whole time. Then I contacted Katie's lawyer and got sucked in and believed him too. If it would be easier, I'll give you full access. And that's what that says. I am not trying to hide. I am not hiding documents or anything for Katie. She doesn't have my phone number. I was never in her Discord or a mod for her. The only Discord I was in was the one that Housewife was in. I did have another Discord account before, but I didn't use it. I was invited to one ran by a man. Okay. People were calling CPS, calling the police, posting pics of people's houses and saying they weren't safe, showing pictures of their guns, etc. I was afraid that's all fair because that shit gets way out of hand way fast, like way fast. If I've done anything illegal, I certainly take responsibility for it. If me saying that my friends and my family will stand up for me and my kids is a crime, then so be it. I mean, we're not going to get into it. We're going to get through this because we've been talking for over 2 hours, like 2.5 hours, and there are still 7,000 of you here. I appreciate all of you. Do the YouTube things. Okay. Because I do not accept direct messages on my Twitter account from unknown accounts, the above messages from Barnhart were held up in a spam filter and I did not check until the morning of January 12th. Once I saw the messages, I texted Barnhart's number and informed her that I received her messages and to inquire about a convenient time to schedule a call. She texted back that she could talk and call my cell phone. And then there's the text. As soon as Barnhart called me, I joined Levine to the call so I would have an additional witness to help document the conversations. Miss Levine and I spoke with Barnhart for 11 hours. We've seen all that in the motion. In addition to reinstating one of Barnhart's Twitter account, her other Twitter accounts, which she also used to communicate with Paulson, could not be reinstated. Barnhart forwarded a number of emails between herself and Brown for our review. We saw all of that in the motion. Below is a true and correct copy of a screenshot of the message I received from Barnhart, wherein she stated that she believed the hackers were actively in the process of deleting emails from her email account as we were speaking. I think they are in the process of deleting emails in my other account. And that might be because what we saw in the Lori Ann emails back and forth between her and Brown was different email addresses. But this is around the time that a lot of people's email addresses were being attacked. And if her emails were being attacked, how does Brown even know if he wasn't on the phone with her, which emails are actually from her? Ms. Barnhart also frequently told us both orally and in writing that we have her full permission to review her social media accounts and emails so that we could verify and confirm everything she was telling us. Like, oh, here's the receipts. I'm saying this. Here's the receipts. And this is them saying, look, here's receipts. To be certain, Barnhart sent me in text message. She has a tendency to initially jump to conclusions based on her feeling intimidated by people or stressed. As such, Barnhart apologized for this trait and said she should come with a disclaimer and that she very much appreciated that Queen Levine and I were taking the time to go through her documents and social media history with her to refresh her recollection, which means, oh yeah, I forgot that I said that. Oh, I also forgot that I said that. Below is a true and correct copy. As you can tell, I jump to conclusions a lot. I should apologize for that. I mean, it's a fair self-awareness. At the beginning of our conversation with Miss Barnhart, she explained that she has certain personal health issues. As such, I knew it was important to treat Barnhart with patience and respect. And therefore, Queen Levine and I remained on the phone with her for approximately more than 11 hours the first day, carefully going over documents with her in real time. During the call, Queen Levine and I reviewed Barnhart's emails with Brown and noticed that it appeared in attorney-client relationship. And that was in the motion too. Slimeball cut off communications. During our conversation with Barnhart, I asked if she would reinstate her Twitter account. I signed into and went through a significant portion of the history of Bloodtall's Twitter account. In doing so, I reviewed hundreds of instances where Barnhart and Paulson interacted and communicated publicly with one another. Dude, they've seen everything. So they've seen everything between Lori Ann and KJ. Well, everything that wasn't deleted before this. Specifically, I personally saw that stating in or about January 20 and to August 20, Barnhart and Paulson interacted almost every week and sometimes several times a day. Attached is an exhibit of a small sampling of screenshot interactions. Look, they're talking more. At one time, Paulson also made a deliberate effort to inform Barnhart that Paulson followed Barnhart on Twitter. Below are true and correct copies. And we saw some of these in, I actually follow you, Lori. We saw these in the other one, in Levine's other one. On the same day, I interviewed Barnhart and I had been made aware of and watched a video of another YouTube creator that goes by the name of Unirock. Specifically on August 14th, Unirock posted a Periscope live stream called Live Scope. And this we saw part of in Elana Levine, Queen Levine's, since that motion has been granted, and Queen Levine's declaration as well. There are 2 Loriannes in here. Someone's fake. Oh, it's put in a Dropbox. So if you have the documents, you can watch it. I then watched a video that we've seen this in a couple declarations where Lori's in the 100K celebration live stream. I downloaded the video directly from YouTube. We know that Lorianne was a member. Those have been in other declarations. Also, during the January 12th interview and along this vein of questioning, I asked Barnhart about the ways in which she would communicate with Paulson. She would mainly communicate with her through Facebook direct messages, Twitter direct messages, and then on Twitter. She initially could not remember whether she had communicated with Paulson via email. And then she said, I reached out to her in April 2020, told her my life story, and that was an email. First, I asked how it is that she could tell Paulson her life story without telling Paulson she lived in or was from Washington. Barnhart stated to me and Levine that she definitely told Paulson she lived in Washington as part of her life story. She also said that she was Facebook friends with Paulson and that her page expressly stated she lived in Washington. This was all in her declaration. So this is again showing, look, this is why we wrote it in the declaration, because we wrote it in the declaration because we have stuff to back it up. Oh, okay. Given the existence of an apparent significant connection between Barnhart and Paulson that we had documented through Twitter and said videos, I asked Barnhart about Paulson purportedly assigning tasks for her to perform on Paulson's behalf. I specifically brought to Barnhart's attention the following screenshots I have obtained from Twitter. I discussed the below screenshot of Paulson telling Barnhart that she knows her ride or dies will always shut Miss Paulson's detractors down. Yep, she's been dealing with it for a long time. I don't know how she does it either, but you can tell that they are not okay. Pretty sad lives they live. Ignore them because I know my rider. I ignore them because I know my ride or dies will always shut them down. I discussed the below screenshot with Paulson. Below screenshot of Paulson telling a fan that she considers Barnhart my fiercest and loyalist. You're amazing, Katie. Such a strong person. I want to be like you when I grow up, even though I'm older than you. LOL. My fiercest and loyalist next to Blood Tall and a real housewife. I discussed the below screenshot of Paulson telling Miss Barnhart's friend that she is not worried about her detractors because you and Lori will be on the hunt. These are all going to the examples of, hey, we were told to do things, and that's all in Lorianne's declaration. And again, here are the receipts. And these have been in that as well. I asked Miss Barnhart if Paulson ever asked her to flag mass flag or report any videos made by or the YouTube channels of Miss Paulson's detractors. And then flagging content means reporting it through terms of service or inappropriate content to YouTube. Then there's a reference. Miss Barnhart was initially reluctant to answer this question out of fear of implicating herself and being added to the lawsuit. I get that, but a TOS violation is not a defamation lawsuit. In response, I assured her that we have no intent of adding her as a party to the lawsuit. Once assured, that makes sense. Once assured, Barnhart told us that Paulson had asked all of her viewers to mass flag the content of other YouTubers. Specifically, Barnhart told us that Paulson would ask her and others to help mass flag competitors' YouTube channels that made negative comments about KJ in order to have their platforms demonetized or taken away. Oh, the active deplatforming of people. Great. Barnhart stated that she recalled one such account wherein she was told to flag a video from Little Red, a YouTube creator and competitor of Defendant, who was publishing negative content regarding Paulson. As a point of confirmation, I subsequently viewed a video on YouTube dated November 8th, 2020, titled Why You Shouldn't Break TOS. This video is a documented collection of multiple instances, fascinating, wherein defendants had publicly asked solicited viewers and followers to mass report other YouTube creators, amongst other people and companies, including the instance identified above by Barnhart specifically, and then they timestamp it. I heard Miss Paulson state, please report her video. She cannot do this. This is like against terms of service. I then heard Paulson say at the 129 mark, please report her video. All right, well, I'll do it from my computer. The video shows Paulson purporting to flag Little Red's YouTube channel, and it's in a Dropbox. On November 8th, 2020, I saw that in the video's live chat, a person using the YouTube moniker Canis Duris, which I understand in his account belonging to Paulson's husband, wrote, thanks to everyone who has reported so far. Oh, fucking hell. Thereunder, I saw that another of the participants of the video's live chat responded with comments such as, how do we report it? I just reported her. Not sure I did it right. Reported it. Is all of this going to get to YouTube at some point? YouTube. There are receipts. KJ might end up deplatforming herself through the mass flagging. Yikes. Ms. Paulson's public request to mass report another YouTube content creator. They're literally leeches. Why are they streaming you on? So this is all here. I know, Katie, it's you or uni. It's getting ridiculous. Reported it. I then saw the video went on to show more of the purported live chat from said video, including the following statements. I thought it was against the rules to ask people to mass report. What am I missing here? What is this stream about tonight? Mass reporting? I also saw that in said live chat, other participants stating that the YouTube creator that is the subject of the mass flagging request is little red. Below is a true and correct copy of a screenshot I obtained from the video's memorialization of said comments, right? Because I wonder if those still exist or if this video still exists. I thought it was against terms of use. This information, therefore, provided me with a basis for developing the good faith beliefs that Ms. Barnhart was being completely truthful about her being publicly asked to mass flag. Well, I understand why. Because now Saltz is just saying, here's the receipts. When Lorianne said I was asked to mass flag, I believed her because other channels had recorded the request to mass flag. Here is the evidence backing up the statement. Okay. What page are we on? 27 of 49. Sweet. I asked Barnhart if Paulson had ever asked her privately to flag or report a content creator's channel. Barnhart responded in the affirmative. Barnhart then described an event where Paulson instructed her in a direct message conversation to flag YouTube creator and competitor's YouTube channel named Sherelle's World. Barnhart stated that it occurred when she brought a video on the Sherelle's World YouTube channel to Paulson's attention. Paulson told Barnhart to report it and instructed her how to do so. Barnhart then stated she followed Paulson's directions as requested and reported the channel for having inappropriate content. Although Barnhart was unable to produce the direct message conversation in which she claimed to have been instructed by Paulson to report a YouTube channel, the story Ms. Barnhart told us was corroborated by information that we had been provided of other instances of Paulson reaching out to others privately to solicit mass reporting. Good fucking God. It's not okay to run around and be like, report this channel, report that channel. Like, it's against terms of service and it's just a dick move. Specifically, by way of example and not limitation, I have been provided purported screenshots of private direct messages between Paulson and another individual wherein Paulson seemingly asked the person, do you have trolls that can mass report? I have been provided no information to make me believe that said screenshots have been fabricated. Send in the troops to that page. I sent them. Steve McRae, I used to co-host on a channel he ran with his partner Kyle. They split and I'm not connected to them at all. Well, good riddance to MS Bad Eyebrows. I hope you have a wonderful Thanksgiving with your family today, girly. Eat lots of food and enjoy the day. Do you have trolls that can mass report? Like, how is that even a fucking question people are asking people? Do you have trolls that can mass report? I don't even know how that would work. LOL. Oh, well, I'm just a little Canadian gal who supports you. No internet genius or anything. LOL. Is that a thing though? Like on YouTube, like people can buy likes and subs. I know people can buy likes and subs. You guys, this is so fucking messy. And again, none of this would have all been splattered all out of here if one, that comment hadn't been in that first declaration, and two, if Brown hadn't wrecking balled the fucking wall for Saltz to bring all this in. Because at the end of the day, it just makes KJ look bad. Like, really bad. This looks bad. Just like go on YouTube and do your thing. What is this? Miss Barnhart also sent me a text message on January 13th. They are going after this mass flagging thing hard. I'm waiting for YouTube to take notice. Making sure that she had used the term mass flagging correctly in her rendition of the events described. This we've already seen. These DMs. On January 13th, Queen Levine and I spent another 5 to 6 hours communicating with Barnhart. Barnhart described the circumstances and events that ultimately led to Barnhart tweeting about her toxic relationship with Paulson and that she was better off having created distance between them. Attached as Exhibit 2 are true and correct copies of various screenshots. This is the Lori, I adore you one. We've seen that. Based on Barnhart's answers and supporting documentation throughout the interview, I believe that sections of the proposed declaration that Mr. Brown wanted Ms. Barnhart to sign under penalty of perjury contained false information. I feel like they could just turn this around and make this a motion for sanctions at some point. It's like, oh yeah, I know you are, but what am I? Boom. So this is the sections of the declaration. We've already gone through it twice, so I'm not going to read them again because we've already gone through it twice. Also, we've already gone through it twice. This is the telephonic conference of counsel. I imagine this reads very similarly to what Queen Levine already said. And this is Saltz just saying, I didn't say that. Mr. Brown's declarations indicates they told Mr. Brown during the call that Ms. Barnhart is easily confused, has a poor memory, suffers from foggy thinking, especially when she is under unusual stress and anxiety, and is taking certain medication as she had been dealing with the prior several weeks. This, they insist, explained why she told Mr. Brown a fake story over the period of 18 days and 150 exchanged emails. Brown's entire recantation of said discussions during the telephone call is false. The judge is going to lose her fucking mind because she said on her call, on the status call, she said, I don't want to do who said what to who back and forth bullshit. And we are in who said what to who back and forth bullshit because grown attorneys can't represent the phone call the same way. It was, oh, they said this. And we absolutely did not fucking say this. Good Lord. Saltz says, what I said during the call was that Ms. Barnhart suffers from personal health issues for which she takes medication. I said that a side effect of that medication, when it kicks in, makes her foggy. I explained to Brown that Barnhart advised us at a certain point in our interview process that her medication was kicking in. I then said this caused us to adjourn our call on January 12th and pick back up the next day. No one told Brown that Barnhart had told him a false story. I also state that Barnhart was confused by Brown and that she felt he was manipulating her to say things that were not true. Oh, he told Brown that. Brown knew that before he filed this motion, according to this. According to this, Saltzy told Brown, she said that you confused her because you were manipulating her. And he went ahead filing this motion, knowing that's what the fuck would come out. Oh, God. I also said that Barnhart was confused by Brown. Okay. Additionally, contrary to his statement in paragraph 5 of his declaration, no one told Brown that we rushed to complete the interview. Rather, I told Brown that Barnhart was upset with him because her primary concern was to correct the apparent error in Fulmer's declaration as to the other Lorianne, and that after nearly 3 weeks, he had taken no step to inform plaintiff's counsel of the error. Oh, so he said to Brown, we told you that she was pissed. We told you why she was pissed. And all of that goes to back up what's said in her declaration. But you're going to go ahead and file a motion for sanctions anyway, saying that it's false. Oh, okay. Here, we're just going to lay it all the fuck out. We're going to lay it all out. All of it. During the January 27th call, Brown asked about the mass flagging. Queen Levine informed Brown that there have been videos made about defendants instructing others to mass flag. She said in her declaration that they provided him with the receipts. What the fuck? I have a header? There's a header. That's my name. Why is that my name? Why is there a header? Why is there a whole header? Why is there a whole header? Does there need to be a header? What happened to jurisdiction? I am so tired. A whole header. Hi, I'm Emily D. Baker. I'm a YouTube lawyer. No, I'm kidding. I actually don't work for Google. I just do, the legal commentary things on the YouTube. But all right, let's continue. Mr. Brown incorrectly speculates that I have some sort of pre-existing relationship with YouTube legal commentator and everyone's favorite YouTube legal commentator. Now we're just getting punchy. And creator Emily D. Baker, and or that we are in some manner influencing Miss Baker to produce content unfavorable to Miss Paulson. Yeah, that's a big nope. I have had no pre-existing relationship with Miss Baker. Accurate. I think we probably crossed paths, but there's no pre-existing relationship. Although we've both worked at the Los Angeles County District Attorney's Office, I stopped working there in the late 90s, and it's my understanding that Miss Baker started working there in the mid-2000s. Accurate, 2006. I have never asked Miss Baker to cover any aspect of this case or say anything about Miss Paulson. Correct. Rather, it is my understanding that Miss Baker obtains copies of the court documents, yes, I pay for them, in this manner and explains them to her audience in a manner that non-legal professionals can understand. Correct. Or I hope so. I hope that the legal muggles can understand. The fact, hi. My husband just walked in. Probably looking for car keys to go pick up our son. Absolutely. You can come say hi. I'm reading about me.
I know.
Do you want to see?
It's probably a good time to come in.
Do you want to see what's said?
Wow, you get your own heading?
I got a header.
You got a whole header.
It's so ridiculous.
That is.
Ridiculous.
Yeah.
Yeah. Saltzy now has to explain that we actually...
Who's Mr. Brown?
The other attorney. Don't even worry about
Sounds
it.
like Reservoir Dogs. Mr. Brown.
Bye.
All right,
bye. I have never asked Miss Baker to cover any aspect of this case, accurate, or to say anything about Miss Paulson, accurate. Rather, it's my understanding that Miss Baker obtains copies of the court documents. Yes, I legally purchased the documents from, the court website. Rather, it's my understanding that Ms. Baker obtains copies of the court document in this matter and explains them, this and others, and explains them to her audience in a manner that non-legal professionals can understand. I hope I explain it in a manner that the muggles can understand. The fact that Miss Paulson and or Miss Brown The fact that Miss Paulson and Mr. Brown perceive that the coverage of this case by Miss Baker is unfavorable has only to do with the nature and content of the filings in this case, and not because of any alleged alliance. There is no alliance. It's the motion to dismiss in the 45-line paper for me. And you know what it is for me? It would be great if you could go ahead and say that you felt threatened. It's the unprofessional behavior for me. It's the not following the court's standing order for me, because it's the not following the court's standing order for me. It's the 45-line paper for me. It's the fact that by sister is the entire motion to dismiss, but it doesn't actually move to dismiss defamation. But agree. I agree. Agreed. Agreed. Okay. I declare I like that we're the closing paragraph. Hi, y'all. I'm Emily D. Baker. Apparently, we're YouTube famous now. I say it as a joke. Oh, my God. Look, the thing was, I don't understand why Brown kept trying to say there was something. I find Saltzy's filings amusing. They're probably written by multiple people in the office. I love a sassy footnote. I love following the paper. I like watching attorneys do good work. I think that they have done good work in this case. If I think that something isn't done well, I will say it's not done well. That's what I'll say. Because at the end of the day, I just don't, I'm entertained with all of you, but I don't even know how this case has gotten so far off the rails. And this grand conspiracy, there is no conspiracy. You know why? I cover a lot of cases. This one's gone the fuck off the rails of anything I've ever seen in my life. But the only reason I think this is here is because somehow KJ got twisted when Saltzy provided me something not related to this lawsuit to read. Why did I reach out to him? Because we had both worked at the DA's office. Just like any other DA that I don't know, I would reach out and be like, hey, you worked here. I worked there. Can I ask you about this? And you know what lawyers would say if they can't talk about it? They'd say, no, I can't talk about that. And I'd be like, okay, cool, boo. Y'all, there is another declaration, but we have been on for 3 hours. I imagine I'm going to peruse it real quick. This is the next declaration is from Jeff Belanco, the real quick Washington counsel. I imagine that this reiterates the other things. I participated in this court's status conference. Oh, wait, there were supposed to be exhibits on the other one. Hold on. Let's see if there's exhibits. There were supposed to be exhibits. Let me see if there were exhibits. I forgot to see if there were exhibits. I saw the deck. I saw the signature page and I was like, oh, we're out. We're free. We're free. Oh, here's the exhibits. And then I didn't pull up the exhibits. Okay. Undo the swoosh. Undo the swoosh. Because we didn't pull up the exhibits. There are receipts. These I think are probably the same that we've seen. KJ chatting with Lorianne, more boom. KJ and Lorianne interacting. These are more than a few interactions is the point. More interactions. More interactions. Exhibit 2. Interactions with Lorianne and Julie Virgo. I think they're talking about Katie. More conversation about it. Okay, and that's the end of that. So the next declaration is Jeff. Hey, Jeff. Jeff's the attorney that was emailing back and forth with Brown after the phone call that's in Brown's declaration. And Jeff is like, actually, that's not what we said. Before Brown even filed this, he knew that there was a discrepancy between what was said because it was in the emails. I participated in the court's February 2nd, 2021 status conference. Same. Well, no, I didn't participate. I witnessed. I attended. Attached as Exhibit 1 is a true and correct copy of a selected portion of the verbatim report, the actual transcript. And then they talk about the motion and why. Okay, that's it. So it's really just the transcript. This is what the transcript looks like. This is the hearing date. And this is Brown telling the court. This is Brown speaking. So it's just very aggravating for us to hear him again, him being Saltz. And I can say that because I participated in the phone call. Him saying, we're not accusing her of doing it, not accusing KJ of hacking. But here are the reasons why we know she's doing it. In the Kennett declaration, Ms. Kennett says, quote, I knew Ms. Paulson was not being honest with me when she denied that she was behind the hacks. That is directly pointing the finger at Ms. Paulson. Oh, so he wants the court to believe that Saltzy's saying that KJ's the hacker based on a misrepresentation of a fucking declaration. No, sir. Nope. And then argues it, you guys. Misstates it and then argues it. This is directly pointing the finger at Ms. Paulson. She says, quote, I believe these accounts, quote, that are hacking her and harassing her, quote, we're working closely with Ms. Paulson. So Mr. Saltz just told the court that Ms. Kennett didn't accuse Ms. Paulson of doing this. The declaration in black and white says it did. Holy shit. He argued to the court that Saltz is misrepresenting things to the court while he's actually actively misrepresenting a declaration. It's like fucking lawsuit inception. Good God. I don't want to believe we live in a post-factual world, Your Honor. Oh my God. You guys, you cannot make this up. Who's writing the movie? You can't make this up. I just misquoted and besmirched opposing counsel with a misquoted declaration and then said, I don't want to believe that we live in a post-factual world. Stop it! I'm dead. I am dead. I don't want to believe we live in a post-factual world, Your Honor. The declaration says that. And what Mr. Saltz said today does not take away what the declaration said, except that it doesn't fucking say that. We're going to pull these up side by side on Friday during Friday Night Live. The court, Mr. Saltz, it sure sounds, he's reading from a declaration that says exactly that. The court relied on the exact quote. Sorry, Your Honor. What he's reading from is a comment that said that the hackers had private information contained from a private conversation that she had with Miss Paulson. And that was what she was talking about, along with what we call the dog whistle statement, where they went after her with regard to certain events. Oh. The beginning of this motion came out so hot with that misrepresentation to the court, but the fucking transcript is brutal for Brown. That transcript is brutal for him. Brutal for him. Because I'm going to pull it up one more time, what the Nat declaration said in this motion. And then I'm going to check Pacer. And then, look, we've been on for 3 hours. We're going to make sure nothing else has happened, right? They've been kind here because that whole transcript is fucking damning. It's not good at all. Nat Kennett declaration. I knew she was not being honest with me about her statements that she did not tell anyone to go after me or that she does not, quote, tell anyone to do anything, period. I'm going to pull those up Friday with the transcript and with this to compare and contrast because holy shit. All right. I'm pulling up the chat. I'm sorry it's been so long and I have not been in the chat. This is fucking bad, y'all. Dude, Brown has just pulled the pin off of a grenade that's going to blow up in his face, and it's not good. That's a terrible analogy, but I'm out of good words. It's been 3 hours. I am going to pull up Pacer because this case is wild. And you guys, this is so crazy. This might be the craziest thing we've seen. I don't know what's the craziest thing we've seen in this case? This is bad. This is really bad. You guys have leveraged some massive super chats up there. Thank you, Lori Smith. I'm going to try to get to all of them. Dina said, just title your videos, Tati Who. Lori Smith, thank you so much. Those are really, really generous. Steph Erickson, I never saw anyone who could make legal shit entertaining, yet so easy to follow and understand. By the way, your TED Talk was life-changing. I've watched it 4 times. We love you. Thank you guys. Thank you. Thank you. I'm just seeing the super chats up on the top. This is incredibly generous. Thank you. Thank you, Lori. That's very appreciated. My words have stopped. Okay. Let's make sure there's nothing else in Pacer. Nope. Okay. We're clear. This is the response that we just read, item 65. Awesome. You guys, I don't know if anything else has popped off on social because we've been here for 3 hours. But I can't imagine how much energy that took, how much money that took. And they took their time. We still have another response from Saltzy coming. Like, there's still another one fucking coming. I think the only way Brown is going to get around being removed as counsel is if he concedes the motion, like dismisses. If he concedes the motion to dismiss. But I don't know how this is going to go from here. This is bad. This feels like TV where you're just like, this is not good. Everyone deserves good legal representation. What I'm seeing here is really bad. And it's bad. It's bad. Yes, this has gone wrong. This has gone way wrong. But the misrepresentations to the court the way that they're saying that Lori felt manipulated, like all of it's bad. Sure, we can call Belanco Jazzy Jeff. Sure, we can. Saltzy, Jazzy Jeff, and Queen Levine. Done. We've nicknamed it. Thank you. A huge, huge thank you to the mods, you guys. It is a lot modding a busy chat. It is a lot modding a busy chat when we talk about a kind of a lightning rod of a creator and try to keep it so we're not arguing about the creator. But when the declarations also talk about shit that creator is alleged to have done, it's hard. Thank you guys. Thank you to the mods. They have just absolutely done it. I have not seen a ton of the chat. I'm going to try to chat for just a few more minutes. But here's the thing. We are live tomorrow night for Friday Night Live, and I am going to do a deeper dive into this and just questions for that Friday Night Live so that we can just get to all of it. So mostly questions and then court of public opinion. So that's really the plan for tomorrow night. I need to digest this. And so I'll kind of give you my thoughts because that was my first reading through of it. I will give you my thoughts and then go from there. What, Emily, can you donate 120 and then we'll meet our goal? What goal? What are we talking? What goal? Tell me what we're doing. And then sure. Can the judge simply transform this motion into one for sanctions on Brown? No, it would have to be filed. The court can't do it sua sponte. We love you. You need a stiff drink before tomorrow night. I'm definitely bringing drinks for tomorrow night. Hi from Australia. I'm a very recent fan. Been watching older videos. I saw you mention a Pokemon. I died. I love Pokemon. Absolutely love Pokemon. There's the Pokeball is down there. Little Pokeball. I love seeing you guys saying thank you for the mods. I appreciate it. What was Brown's reputation? We have no idea, but lawyers don't just go off the rails like this. Like this is just, you guys, this is just really, really ugly. It's just not good. It's just not good. Thank you guys for the super chats. I appreciate it so much. I'm going to try to see if I can see some of the ones I missed earlier on because I know they're going to be here. Oh, that's not what I wanted to do because I know that there are some that I missed. And if you guys have just a few questions, we can. I have no idea. I have no idea. Brown has tons of experience, good experience. He has a good resume. I don't know why this is happening, but the misrepresenting stuff to the court is so bad. It's so bad. And Brown's going to have a chance to respond, but the transcript says what it says and the declaration says what it says. I don't know how you explain that. Being careful with the court is literally the thing you should be most concerned about as an attorney. Oh, you guys are almost at 88,000 subs. So if you're still here and you haven't subbed yet, you've been here for 3 hours. So maybe consider subscribing. No, all of the live streams aren't this long. And I've started playing around with some YouTube shorts. I know they're not for everybody, but YouTube loves them right now. So we're going to just let YouTube love my channel a little bit because, YouTube things. And I love being a YouTuber. I love doing this. I'm going to look for some of these super chats real quick, and then we are going to go. NJ, thank you. Brown has a good resume. He literally repeatedly told us. Yes, he did. And now he's showed us who he is. Oh, thank you guys. You guys are so kind. Can we get bus washing my hair and I'm a header merch? I mean, we might have to. I'm busy washing my hair. Maybe I'm a header might have to happen. The header might just have to happen. Thank you so much. You guys are so fantastic. I'm shook. I'm shook. I don't know what's going on with Creep Show, but I will look back through the chat and try to figure it out. We do love Creep Show. I'm loving the shorts. Thank you. Look, They're an experiment. We play with having fun on YouTube. YouTube loves them. I'm trying them. I know that some of the audience is intimidated when they look at the length of the videos. And so we're going to try to capsulate that for the people who just want the information. And then for those of you that want the deep dive, we can do the deep dive. You guys, I'm pulling up on the back end the amount of super chats. Thank you so much. This community absolutely blows me away. And I am so proud to be here. And I appreciate you guys so much for wanting to understand the law, wanting to talk about it. And so we understand it. And then also being here for the team, being like, what in the fuck is happening with this case? This case has gone so far off the rails. I don't even know. At some point, is KJ going to turn around and sue Brown? Or is this their litigation strategy? Like, what is going to happen next? I don't know. You're dyeing your hair purple in 2 weeks. Well, hopefully we'll hurry and we can do it the same. I did set my cups up and I put it on Instagram. So if you guys are following along on Instagram, you'll see it. And I put those on Instagram and I'll put them again today because I don't think I remembered to put them in a highlight because I always forget to do that. So I didn't know that. But let me try to get to a few of these. You guys, so many super chats. Thank you so much for all of the support. As I said, I am honored to be a part of this community. I love that you guys are here for the long conversations. I just don't know what's going to happen in this case. Like, I've never seen anything like it ever. Uncannery said, I honestly think Saltz was taking notes on your videos because I feel like all the points I've seen thus far have been basically from your words. I mean, the attorneys on this case do get to crowdsource other lawyer brains. Like, there's lots of lawyer brains looking at this and lots of lawyer brains looking at this from different angles, which is kind of fascinating. And it's Nick Ricada and I were talking about this on a live stream with Nate the lawyer and with Eric Hunley about this new wave of kind of lawyering in the time of social media and the fact that these things are all going to be read and reviewed. And now you get to kind of almost crowdsource different opinions. Wait, what? Lori, thank you. That's so sweet. That's what you guys are up to. There is a lot going on out here. So let's try to just get to a couple of these real quick. I see one from Doobie Pink Floyd Hippie Chip. I'm obviously behind and just said, why we orange, not red. Emily goes, we got to go red. We're going red. Chloe said, Saltzy definitely knows how to bring it when he needs to. Not only is the sass on point, but it's savage and true. Nate the lawyer. Thank you, Nate. I'm sure you're not still here because I saw you read these this morning. I'm going to go back and watch Nate's coverage. I wanted to read these cold. So I didn't watch it yet, but Nate said, call 911. Saltz just murdered Brown's motion for sanctions. He should consider withdrawing his motion for sanctions. I would think that that's the only way to save this. Either he withdraw from the case, he withdraw the motion for sanctions, or maybe he withdraw the motion to dismiss and just not make it so that it's not necessary to even have Lorianne. Lorianne's relevant to jurisdiction. If they concede jurisdiction, Lorianne's only relevant now to all this other shit, but also potentially to the fact that KJ might have stuff in her declaration that's contradicted by stuff Lori said. You guys are so kind. My best friend keeps rolling her eyes at me when I text her the lawsuit. She isn't as cool as us. This lawsuit's fucking crazy. I texted my legal friends about this lawsuit and they're like, no. Oh, thank you guys. I know. I was like, look, we would have never have gotten through this. Oh, thank you guys so much. You are so kind. Miss Raven said, so mad I got stuck in meetings. Replay for me later. Donald Duck said, Saltzy serving facts, sassy as can be. I'm here for this. Brown is probably in tears calling his mom. The receipts, Whitney. Charlie said, can you make sanctions? You can't make sanctions happen, Gretchen. Sanctions are not going to happen. Thank you for getting my reference. Sanctions are never going to happen, just like fetch. Thank you so much, Lori. And thank you guys. You guys, I appreciate you so much. Question, is there a deadline date that the court has to answer to this mess? No, they have to set a noting date for it. Donald Duck said Brown attempted a Hail Mary and Saltzy came in like the water boy and knocked Brown out, kind of. Donald Duck said, can we get this case into a game of Monopoly? I'd buy it. Terry Lynn said my line was always, I have important cat shit to do, or I'm going to my cousin's cats or my friend's wedding. Witch Stitch Witch said, this is office policy now per your last crappy declaration. Lori Smith, ethics always come back to snake bite us. These ethics are going to come back. This is just, it is bad. Thank you so much, you guys. Thank you. Thank you. Thank you. Creepshow did delete her Twitter. Babs is going to lose her mind. But before Babs loses her mind, there's a lawsuit. There's a law research attorney that is going to have to read all this and then be like, okay, but this is ridiculous, and then be livid. And then be like, but what the fuck? Lori Smith, hey, law nerds, I will donate another 100 right now if 1,000 more of you will do. Oh, thank you, Lori. Thank you guys for being so kind. I would be here for another hour trying to read all of these. So I'm going to go and absolutely look at these before Friday so I can thank you again. I want to buy Law Muggle merch. I'll have to make sure Muggle is not something that we can't make merch into. It might just be a phrase because I hate the phrase layperson. It really is just law muggles. Like, you just haven't learned the magic yet. And once you learn the magic, we all know the magic together. I can't, Courtney, it's really hard to say because I don't know what their strategy is. If this is what is being asked for, if the marching orders from the client are go hard, I don't give a fuck, then no, it just depends what's going on. But KJ's going to know what her attorney's up to because it's all laid out in this. So you guys, thank you. Thank you so much. You guys are so sweet. Thank you. All right. You guys, do we need to bring back Lawyer Cat to wrap up? Should we wrap up with Lawyer Cat? I feel like we should just wrap up with Lawyer Cat. If Brown has disqualified himself, does KJ have to pay him? Yes, but then that would probably get argued over too. Because if I was the client, I would argue over it. I would absolutely argue over it. But yes, she would still have to pay him. Yes, Lawyer Cat. Yes, Lawyer Cat. Yes, Lawyer Cat. All right, Lawyer Cats. You guys are so great. I'm here live. I'm not a cat. Meow. You guys have been fantastic. As we wrap up this chat, I just have no idea. I don't have words. I'm going to process all of this. I need to sit and think about everything that we've seen here today. I need to think. And then on tomorrow's live stream, I will give you my thoughts about it in a cohesive way. And then we'll just answer questions and talk about this the entire time because there's so much to talk about. I just can't. I'm sure Muggles is copyrighted, trademarked, and all the things. I'm sure it's all the things, which is why it can just be an inside joke here and not merch. We can be law muggles. We're law nerds, but I will just be using muggle instead of layperson because that's what we do. We break it down for the non-legally magic. You guys, I'm blown away by your continued support. I'm out of words after 3 hours. I appreciate you. I love this community and I love being here. I love that you want to understand the law behind it. We're not going to see other cases like this. The Girardi case is wild in a different way, but we're not going to see other cases like this. This is unprecedented for me. This needs to be an entire ass class in law school. It needs to be a movie. It needs to be everything. It needs to be all the things. It is bizarre. And I can't wait to see what comes of it. Like, I'm so invested in the novella that has become the Tati Westbrook, who is she anyway, in this defamation suit. Like, the thing is, though, people are behind this having to pay for this. This is so deeply stressful, I'm sure. And Brown pushing these motions forces plaintiffs to respond. They are obligated to respond, which pushes the cost for Tati Westbrook too. And I just don't know who benefits. I can't imagine that KJ is going to outspend Tati. It's a strange litigation strategy. This is DOA Will we see Brown remove the motion for sanctions? That could happen. That could happen. That could very well happen. It might have to happen. Brown's got to be pissed. But also, don't say shit that you can't actually say. I'm dumbfounded. I maybe Scott, but also Brown normally does insurance litigation. So this is not how this goes. I talked about this on Sherelle's World, and so I'm going to do a bunch of questions tomorrow. I talked about this on Sherelle's World, so there's a video with me talking to her about it. There's a lot of it depends factors in that, but there's a lot of legal documents in here that if YouTube was paying attention to was like, oh, there are sworn declarations talking about terms of service violations, at least enough that YouTube can look into it if they choose to. And who knows how they decide to do that. I don't know how we got here. I didn't think that this is what was going to happen. Like, I didn't think this would be this fucking crazy. I don't know who's benefiting from this as a legal strategy. It's not going to be Brown. Babs is going to be pissed. If I was opposing counsel, like if I was Saltzy and Levine, I'd be like, why are, like, it doesn't make sense. And then I would be fucking pissed. And I don't know. We've seen Brown's perception of the case. I don't understand the misperception that I'm seeing. I don't understand I'm quoting from this document, but it doesn't say that. That transcript is bad. Like, that transcript is bad. All right. 3.5 hours, law nerds. Over 7,000 of you in here. I'm sure more during most of the chat. I appreciate the fuck out of you guys. I will see you tomorrow night. I'm going to go rest my voice and eat some lunch and try to process what I just read, because bombs have been dropped. Like the boom gift that you guys were leaving on Twitter. This was it. This was something else. This was something else. Enchanted Wings, we are working on more merch all the time. So I take everything under consideration, but my brain has stopped. So I'm going to take it under consideration. Quick, is Brown not doing the exact same thing KJ is getting in trouble for with the business partner lawsuit and her factual coverage? It feels like, oh, I've read this document, but I'm not really reading it the way that it says it. It's crazy. All right, you guys, I appreciate you. On the way out, if you could like and subscribe and do the YouTube things, I appreciate it. I love watching this community grow because I love having these conversations with you. And I love being a content creator, and the community growing allows me to do that. And I appreciate it. And I am honored and privileged to get to do it. Give a big thank you to our mods on the way out. It's been a long one, and it's time for everybody to get a drink or a nap or a snack or all of those things. I'm gonna go get my kid from the bus. Thank you for being here. I appreciate you, law nerds. I'll see you tomorrow night on Friday Night Live at 7 p.m. Central. Hey there. If we have connect with me everywhere, I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.